To mention hearing matter. Nandavas appeal.
Are you mentioning about notice?
Yes, with notice.
Here,
May I have your lordship's kind leave to mention with regard?
Old matter. 2017. With notice to the other side.
My lord, may I be permitted to mention for inclusion of application under group 1, my lord. That's
when is your notice?
I have not served the notice.
Please give a notice.
My lord, no, one day in this week, only one day. My lord, I will be serving the notice to the other side, my lord. Next Thursday is a holiday, my lord.
Yes, লিখে দেবে লিস্টে বুধবার mentioning. বুধবার mention. Come on Wednesday, give a notice and come. We will take mentioning on Wednesday.
May I have your lordship's kind leave to mention with
Mentioning with notice.
Hearing or application?
Hearing matter.
Lord, may I mention item number 49 of the day's list, my lord? It's a Pathar matter. If your lordships kindly fix it any day at 2 p.m., my lord. It was prior to the vacation, it was fixed, but could
Mr. Das, it cannot be taken.
but pensionary benefit matter, my lord. My client is in death bed.
No, we would be, we can release the matter.
No,
Because
my lord,
next
that
week
I do not want.
we can release the matter if you want. But my brother won't be available from next week, so you know that. Yes,
Lordship, may I permit to mention one hearing matter? Proceeds, Lordship. I have not served the notice, but I will serve the notice by today, Lordship.
give a notice and come.
My lord.
Come back on Wednesday.
I am praying for updation of item number 60 in the monthly list.
What
Because
is
it
the
is
urgency?
2010 matter, my lord,
Remind us when the combined list come out.
because my lord, 2010 my state has come before this court and the
Please
that-
remind us after the combined list comes out next month. Yes,
My lord, the claims were heard on, mentioned on 8th January, but not it listed kindly. I've served the notice to the other side also.
sorry, we don't take without notice.
we-
Survey notice will take it
Well,
upon Wednesday.
may I permit-
I've already served the notice, and for the case AP of 2024,
An original side.
original side, that's
Wait
why.
for you, wait.
my lord, may I permit to
May I be
mention
permitted to
hearing matter? I have served notice upon the other side.
Hand over the slip letters.
My lord, may I be permitted to mention one group 6 matter, my lord? I have served notice already, my lord.
What application?
Yes, your lordship. My lord,
Application pending.
for inclusion, your lordship, please,
No,
my
no,
lord.
is it application or hearing?
Application, your lordship.
May I be permitted to mention one matter for the inclusion in the list, my lord?
No, এগুলো না। Just
Permitted
give
to
the
mention-
slip- Give the slip.
Yes.
What you have,
My lord, may I permitted to mention item number 24 of the combined monthly list.
for what?
My lord, for early hearing, because it is a urgent matter,
You have to wait, Mr. Mojumdar.
My lord,
We cannot
why I
update.
am mentioning petitioner, my lord, under suspension for more than 10 years.
Entire list has been called.
We called the entire list, Mr. Mojumdar. Please wait for your turn. Wait,
What?
any other
I am
application?
mentioning a service matter.
Pardon?
I am mentioning a service matter for inclusion in the list as
But
application. I
hearing-
have also served the notice.
What is it, hearing?
No,
Yeah.
application.
So item 33 of the day's list praying for early
fine.
hearing. On 25th November, Lordship directed that the respondents come up with instruction why the appellants will not be given the similar benefit given by all the other high courts.
All the matters were called on. You people do
No.
not appear.
This has been listed in the daily list, Lordship.
Yes, daily list also we called. Entire matter, entire list was key, Kartik. Entire list was called. Yes.
My lord, this is original
Wait
side.
for this month. Eh?
Already on
Original side.
original on 8th of January, already accepted, my lord, the same, not yet listed, that's why.
Which one?
AP of 52 of 24, Food Corporation versus Molay Bhattacharya.
Pardon?
Molay Bhattacharya.
What you mentioned earlier?
I mentioned earlier on 8th January, but it was not listed now. You approved, my lordship approved.
Is it assigned to us or a regular matter?
On a regular matter.
Regular matter. Give the slip, but you have to wait because next month it won't be possible. Next month would be possible. You can remind us after the combined list comes out next month.
May
Hand over the slip letters. Here after. Yes, call the list.
Well, I'm pretty short possible. Mr. Chaturvedi is
I am
appearing.
for
in
the
figure.
speech.
Mr. Chaturvedi is appearing, Mr. Chaturvedi.
Mr.
Mr. Piyush Chaturvedi is appearing for the appellant.
I
It is on list. One.
That matter, you also already heard the matter.
What first?
Item 2, I'm for the School Service Commission.
I'm for the review applicant's lordship. Today, Mr. Mojumdar is unavailable due to some
Take
person.
instruction.
Yes, lordship.
What? You are not going to.
Lordship, we are going to press it. Lordship, we will try our luck over here. Lordship.
Not this week. Yes, next.
Much obliged.
My lord, in between this bench might not be available, as it just was fallen from your lordships.
Pardon?
As it just fallen from your lordships, I heard that.
What can be done? It will appear in the list. If it is not taken, it will be taken up next day.
Very well. Not this week.
Or we can adjourn it for a fortnight. As you.
Lordship, at the earliest would be better. Lordship.
It cannot be done because this next week onwards the bench will change. My brother won't be.
Lordship,
2 weeks. Yes. Yes.
Three, I am for the respondent number 1, read petitioner, my lord. Today is, my lord, awaiting for the report from the BLRO.
My lord, as per your lordship direction, I filed this report, my lord, where it is very clear, my lord, that he was present at the time of demarcation. But when we sent the same, my lord, report, he refused to accept that. I know. I know. No.
My lord, in item number 3, behalf of the petitioner lead by Shankar Prasad Dalapati is coming and pray for short passover, my lord.
My lord তো শুনছে, শোনো, আসতে বলো। আগামীকাল ডেট আছে, দেখি তো আপনি যারা আজকে ফিক্স করেছেন আসতে বলো।
And pray for short passover, my lord.
Very free.
Where it is just gate number B coming. Short passover.
But in item number 5,
বললে কি করবে রিপোর্ট টিপোর্ট এসছে
কালকের মধ্যে দিয়ে দেবো ভিডিওর সময় কালকে my lord, in this matter, my lord, there was a direction upon me to furnish a report from the BDO and the DLRO, my lord. If your lordship kindly see the lordship's order, page 2. But the status report with regard to that solid waste management which is being constructed over the land in question, my lord. Now, my lord, inadvertently, my lord, there was a communication gap between my advocate on record and the authorities, my lord, because Ms. Dotto had an operation. She is bedridden. My lord, within 2 days, the report will come, my lord. I've spoken to the BDO yesterday. Within 2 days, it will come.
We are keeping it on carefully ready.
Well, within 2 days, it will come. Exception কিছু তো হয়নি construction আমাকে ফোনে বলে দিয়েছে
নো কনস্ট্রাকশন
Is for extension of
সেটা বলে দাও না করে
is for extension of time to file the
মালটা
February na 31st March. My lord, I am appearing on behalf of the private respondent number 9 to 11. On the last occasion, also the petitioner was not there, lordship. Kindly have a look at the last order, lordship. 26 November. But lord, kindly have a look to the impugned order, my lord. Dismiss for default. Private respondent is representative. Private respondent or represented by respondent for 9. So that this is that the unsuccessful writ petitioners, my lord, have questioned the order, my lord, of the honorable single judge, my lord. That there is a this is barred by section 5, my lord. 105 days delay.
who is for the respondent?
My lord, we are applying for the state respondents.
State.
State.
Any private respondent is there?
No.
You have served?
served, my lord. Affidavit of service টা কই?
Section 5 you have served of
Section
not?
5 served? Yes, my lord.
But 5(3) we couldn't find. Fine.
5.
What is 5(3)? 5 within bracket 3? Akshay Junior.
5(3). 5(3).
You have filed an order 41 rule 20?
Yes, my lord. Certain documents, my lord, that were required to be, my lord, placed before, my lord, the honorable single judge. We could not place it, my lord. But the pleading is not happy, my lord. In consonance or in line with, my lord, the mandate order 41 rule 27. But these are necessary documents, my lord. But section 5, my lord, what my learned senior friend will see.
Yes, what do you say?
What is it up to your lordship, my lord?
Show us the
Another defect.
Paragraph 1(5).
Petition number 2 to 6 and 8 to 10 in the interim order
Section 5.
do not find
কথা
place
না
in the
বুঝে
full
আজে বাজে
title of the memo. You check and
My lord,
remove the defect.
my lord.
Petition number 2 to 6 and 8 to 10. Where is the writ petition?
ওরা জয়েন করেনি।
They have
All are
not-
state.
Petition number 2 to 6, that means Dr. Sujoy Kumar Saha to Nirminendu Mondol.
নেই? ওজন পিটিশনার আমাদের।
Only two are
Only two.
preparing the appeal.
We the
But
two.
the rest should be added as a pro forma respondent.
Yes.
If they don't join with you, then they would be added as a pro forma respondent. Leave is granted you. Huh?
you correct it, Mr. Wali.
Yes, yes. কত স্লিপ
As
করলেন না কেন? একা করে দেওয়া না।
as quoted by the additional
ওদেরকে
stamp report,
বল একটা চিঠি দিয়ে দেবে।
the petitioner number 2 to 6 and 8 to 10
Lord, in item number 8, my lord, I'm appearing on behalf of the appellant, my lord, being led by Mr. Ujjal Rai, my lord. Kindly seize my lord's earlier order, my lord. 16th of December 2024. My lord.
If you in opposition, they have not filed.
So far as scan 1 is concerned, addition of supplement order 41 rule 27. Additional document they want to rely in appeal. Since it is an intercourt appeal and continuation of the trial, I will not stand in that way.
No, this is scan 1 is the application.
Stay. That's a stay. I am talking about scan 2.
You have filed a fresh application for
Yes. Scan 2.
Can 2, my lord.
scan 2 to কি আছে?
Can to additional documents.
No, we directed exchange of affidavits in
For both 1 and 2.
Oh,
My lord.
2 we will not use. Whatever document they want to bring on record. The only question is they want to show that I am a state. I am a society under Societies Registration Act 1961. They want to show that I have a perverse control by the Ministry of the Steel and the finance is coming. So whatever document they want to place, let them place. I will not stand. So far as that case is concerned. And so far as stay is concerned, Lordship, I don't think we have to file anything. They have annexed it.
What stay you are wanting?
Lord, stay of that order, my lord, that was there in the writ petition, my lord. Lord, in that event, my lord, may I just humbly pray, my lord, this morning, my lord, mother-in-law of Mr. Ujjal Rai, my lord, suddenly fell ill and he had to be admitted to the hospital, my lord. That is why, my lord, he is not here, my lord. Humbly praying for 1 day accommodation in that.
You want stay of the cost amount.
My lord.
Yes, yes.
My lord.
That is what you want.
My lord.
Otherwise, there is no other stay you are wanting. Have you seen that?
My lord.
So we will stay that cost portion, Mr.
There also I will not stand on.
Yes, what you have any or you want to do it in his presence?
Lord, kindly makes it not today, my lord. Tomorrow, my lord, Mr. I will apprise, my lord. That even, my lord.
In that case, I will request your lordship to keep it on 24th. Tomorrow and day after, I am not in the city.
24, Mr. I will not be.
Then next Monday, lordship.
স্টেটা করে দিয়ে
তো স্টে তো দিচ্ছে তোমার 10,000 টাকাটা স্টে করে দিচ্ছে আর বাকি মোকদ্দমা পরে হয়।
What is your problem?
করে নাও।
As my lord, please.
ওনার নামটা দিন।
আচ্ছা আমি আচ্ছা so by our earlier order dated 16th December 2000
disposed of.
Yes, sir.
That's complete.
But I am paying for 1 day's time, my lord.
You are for the appellant.
Appellant, my lord, yes. Only 1 day.
For the respondents.
Day after tomorrow.
Much obliged.
এবার এটা password.
May it please the Lordship, my lord, I appear on behalf of the appellant.
For the stay.
My lord, admitted position is that, my lord, under the 2002 rules, my lord, I have applied for renewal of a mining lease. And I applied after, my lord, the rules of 2016 came into force. But my application, blood which I annexed to the writ petition, blood did not, my lord, contain along with it the challan signifying payment of rupees 500, which, my lord, by way of a supplementary affidavit, my lord, I have brought on record. But my writ petition has been dismissed on the ground that I could not produce any document signifying payment of 500 rupees. And then rules of 2002 having been repealed by dint of section rule 62 of the 2016 rules. So this application is now no more entitled to be considered. The impugned order, my lord, is at page 65.
Page 65 of what?
Of my stay application.
This is an appeal of 2017.
Yes, my lord, this, my lord, has been dismissed. But on the last occasion, my lord was, my lord, of the view that
Page 20.
page 65. That my lords would hear me on merits. But that was a, my lord, prima facie view, my lord, expressed by my lord.
Yeah, give us 2 minutes.
My lord.
একটু মাইনর মিনারেল রুলসটা বের করো তো। সেটা এনেছে পরে।
Where is your supplementary affidavit?
Lord, I have filed on the last occasion, my lord. Kindly comes to page 4.
Where is your supplementary evidence?
Lord, on the last occasion, my lord, I filed it on the 16th January. Page 4, my lord. My lord would kindly find, my lord, this is the stamp and seal is of 29th August 2016.
আমার ঘরে নিয়ে গেছিল তো। Page,
Page 4.
please tell us what are the facts.
Yes. Now, my lord,
You were
on
granted mining lease on 31st August 2016.
no, I was not granted mining lease on the 2nd March 2012.
Acha, you submitted the application after the new rules came in.
Yes, yes.
And my lord knows that in terms of Rule 12 of the 2002 rules, my lord, I was to submit the application, not, my lord, any time before 9 months and not later than 6 months from the date when the lease is expiring. My lord, I filed it within this time on the 31st of August 2016. Now, this application is required to be filed in a particular form. Along with this form, the payment signifying the processing fee of 500 rupees is to be annexed. Hence, internal page 4 of my supplementary affidavit, which I showed to my lord, is 29th August. 2 days later, on 31st August, I applied. Now, the 2016 rules, they came into effect, Lord, on the 29th July 2016. Admittedly,
You
my
paid the fees on 29th of August 2000.
the challan is 29th August 2016. The application is 2 days thereafter, 31st August 2016. And the rules, my lord, came into effect, rules of 2016 came into effect from 29th July 2016. Admittedly, my application is after the new rules came into effect. My lord, my point, my lord, which I intend to canvass before my lord are twofold. One, that my writ petition has been dismissed on the ground that I have not been able to produce any document signifying the requisite fee of rupees 500, which, my lord, I have, my lord, produced before my lord, and a leave was also, my lord, sought for before the learned trial judge. It is though not recorded, my lord, in the order, but then, my lord, it was declined, saying that the matter is being heard at the hearing stage, so no further leave can be granted. But the application is there. That the 2002 rules, my lord, I shall show to my lord. They say that even if there is a defective application, on the ground of defect, application would not be rejected. My lord, the time would be granted to make the application inform, regularize the defect, and if within that given time, if it is not regularized, only in that event, the application would be rejected.
How that provision remains? Your rules have been.
I come to that. I come to that. Now, Milord, the second, Milord, limb of, Milord, my argument is that the finding that the rules of 2002 having been repealed by dint of Rule 62 of the 2016 rules, Milord, with regard to that, I say that, Milord, the amendment or the repeal of the old act cannot take away, Milord, the inter-party contractual rights. Whether this, Milord, repeal would trample my rights, Milord, under a statutory contract. To that, Milord, the coordinate bench of our honorable court, Milord, had, Milord, passed an order. I'm sorry.
There is a delay.
Milord, there is a delay, Milord, insofar as, Milord, the filing of restoration application is concerned.
Oh,
Yes, it was dismissed.
It was dismissed. My
Dismissed,
lord
Milord.
was hearing my
Not
restoration
before.
application. Then my lord directed that my lord would not dispose of the appeal because there is nothing in the appeal. My lord expressed that.
Yes, show us what is your point of law.
Yes. My lord, kindly, my lord, comes to, my lord, page 11.
Mr. Roy, we restore it and he will file paper books incorporating.
Mal.
Huh?
Mal.
I need a
Can a copy? A copy may be given to me because it is dismissed, my lord.
Yes, yes.
Actually, yes, section 5 application can.
Section 5
can 2.
Restoration হচ্ছে
Can 2 and can 3. Can 2 and can. These are the application for combination of credit, the application for restoration. And
আর কোনো আছে আরো?
Three. Three.
My lord, I am tendering unqualified apology because of my late, my lord.
হাইওয়েজ একটা বের করতে হবে হাইওয়েজ
ওই কোন কথা কোথায় গেল?
হাইওয়েজ একটা হাইওয়ে দেখুন এটা এটাতে আছে কিনা ট্যাগ মার্ক করেছে
Dhalapati report.
Yes,
copy of-
yes, my lord.
Yes, my lord. My lord, on the previous occasion, I raised the point of locus standi. And the second point was, my lord, whether the inquiry was made or not. Today I have been served the copy of the inquiry report. And from the report, it reveals that the inquiry report was sent to my clients, but my client was not in their house, and the other family members refused to accept the same. And it is true because I checked it up from my client. And my lord, after inquiry, my lord, on
Inquiry report confirms your unauthorized.
Yes, my lord.
Construction. or
There is an
the report confirmed, my lord. After that, I raised the objection before the assistant engineer. Kindly have a look into this.
Assistant engineer will consider the same.
And tomorrow is the date fixed for hearing. And my lord, I raised objection that without PWD made the measurement, and without having any map of PWD or acquisition map, this inquiry report was prepared.
So you argue that before the
Yes, my lord, I will do this, and prior to that, I raised this objection to the assistant engineer. Well, kindly have a look into this, and kindly direct the assistant engineer to consider this objection.
that order is already there, Mr. Dev. That you will appear, you can take all objections, everything, merits not gone into, everything has been stated in the order. Come to the order in view. Upon considering what has been come, PLRO will next page 40 of your state now. Carried out by BLRO within a time. Then in the event such report confirms, then the jurisdictional assistant engineer after issuing a prior hearing notice, which has been given to you, has fixed up a date of hearing. After giving opportunity of it, shall decide the representation 20th September 24. That is your representation.
My lord.
Okay. Order has been acted upon. Even you, in compliance with the order, you have submitted objection before the
My lord, it's true.
jurisdictional assistant
Yes,
engineer.
yes.
Order, a major portion has been acted upon.
My lord,
This part is hearing, and whether he will refer to
my lord, I have no contra argument, my lord.
Interference called.
দরকার নেই।
You withdraw the appeal, Mr. Dhalapati. Why you are wanting a rejection from us? When you are, anyway, we will.
At least, my lord, my
my lord,
humble submission is
If order is
kindly,
passed, my lord, he is
kindly
senior.
direct the assistant engineer to consider my
Yes,
objection.
that has been said. Already stated. You know,
the appeal challenge, that is the order.
That is the order. তোর অসুবিধা নাই তো?
Representation.
7th November 2024, passed by the learned single bench in WPA 261
Well, my lord, he's on his leg before code number 1. Kindly adjourn for the day, my lord. This matter.
Not today.
Oblige.
12 and 13 effect to appeal for the appellant petition.
Well, a copy of the Millard affidavit in reply, Millard. Millard, I got it only on Friday, Millard. Millard, I am playing 1 week time, Millard.
Is it any application?
My lord,
Application
for hearing of the appeal, in a sense, my lord.
Final hearing?
For final hearing, there is no scope for any stay because there is no scope for any stay.
Very good. You file your paper book then.
My lord, we can, if your lordship so directs, we'll file a.
We will dispose of the stay. We will
This
give
is
you
not stay, my
no
lord.
stay
This is for
application.
hearing of the appeal itself.
Oh, there is no stay.
There is no scope for stay, my lord.
The application is pending, Mr. Shamol.
My lord, this is my application, my lord.
What is that application? Application for appropriate order.
Application for appropriate order.
Well, right, Millard, copy, Millard, I.
Are Baba,
Yes.
So, what? So, no further order is required to be passed.
In a
What
sense-
appropriate order
My
is
lord,
sought?
for hearing of the appeal itself, my lord.
Hey, near enough. We will dispose of that application. He will file paper book within 4 weeks, and the matter will appear in the combined monthly list of March.
Grateful.
For hearing.
Filed on behalf of the petitioner.
Experience.
pleadings and documents.
May I pray for a short passover?
But I'm for the petition.
I'm for the respondent number 2. May I pray for a short passover? Mr. Shakoshan is appearing.
The affidavit is.
It's coming.
Sure, this is very urgent matter, my lord. Your lordship kindly see the metro railway
We
acquisition
will
matter.
address your lordship today itself. Short passover, I'm saying.
Take it up tomorrow then, Mr. Dughosh. It will
It
be
can
at
be
the
taken
top
up
of
today if
the-
your lordship kindly. Short passover may be granted.
No, that can, she is the respondent. Come tomorrow. Tomorrow is same position at AKP.
But RVNL has not come. In spite of service, private respondent has
RVNL
not
has
come.
come. I am appearing for RVNL.
Oh, then Metro Rail, Mr.
Metro Rail,
Shakoshan is
Metro Rail.
appearing on behalf of Metro Rail.
No,
Metro
for
Rail,
RVNL.
anybody is appearing.
Today I find there is no one
All
appearing.
right, we pass order tomorrow. Ask Mr. Sen to be here.
But,
Yes.
It comments to your lordship instead of tomorrow, may it be taken up day after tomorrow.
Lord,
Why, sir? He's having arguments tomorrow.
Yes.
He's on the way. Let him start. This is the, I'm for the appellant, my lord. My lord, today I seek my lord's kind leave, my lord, to file a supplementary affidavit.
Time for the SO number 2 and 3 led by the learned government leader. It's for the state.
Supplementary affidavit to court. My lord, may I?
Supplementary affidavit.
Affidavit, my lord. My lord, I tell your lordship, my lord, a tender was.
We have not received any copy of supplementary.
No,
affidavit.
I have not, the leave has not been granted, my lord. My lord, if leave is granted, then I should.
No, supplementary for enhancing the records. Any further documents?
No. Only enhancing the record, only, yes, my lord. Enhancement of the record means, my lord, the answering respondent has laid down a particular criteria for enlistment of the operator, giving it a different nomenclature, which does not find place in the statute. The government, my lord, in the mining sand operation, my lord, it is guided by the 2021 rules, my lord, framed under the Act. Now, my lord, in this,
Mr. Basu, then give a copy to him.
yes,
If
I
he
believe
says
what
he
my learned friend is now trying to implement by way of supplementary affidavit that was not before the honorable single judge.
right.
Right. That
No,
is
pleading
why-
is there. Pleading is there, but the document was
If
not.
something was not before the single bench, your lordship can whether
No, that I will
decided in the
address.
appeal.
I will address. If I'm readily giving the answer. Millard, section 107 of the Code of Civil Procedure says the appellate court exercises power like the original say, or the original suit court. Now, Millard, this is the principle, Millard, applies to your lordship's proceeding. Now, Millard, if your lordship, Millard, the original writ petition is basically a original proceeding. I have made a pleading, but I could not file the document, Millard, because I said that the criteria that was set out by the authority, Millard.
Mr. Basu, give a copy to him. We will hear it tomorrow.
Yes, Millard. Here.
এটা নিয়ে নাও supplementary
Supplementary
affidavit
affidavit of
নিয়ে
service.
নাও file it tomorrow. Give a copy. You are the sole respondent.
No,
No, I
state
have
is
not
there.
said
Mr.
that.
Day is representing SO number 1. I am for SO number 2 and 3.
Mr. Basu, give the copy
yes,
to
yes.
them.
Sorry,
And tomorrow you file the original. We will pass appropriate.
Deeply obliged. Deeply obliged.
This was item 16.
Yes.
And ওই যেটা আরেকটা মিস্টার ঘোষের মামলা আচ্ছা yes
My lord, this is also an appeal. My lord, this is arising out of an order passed by the LRTT. My lord, it was initially tagged with the other two appeals of Mr. Shoptangshu Basu, which your lordship is hearing on the point of resumption under section 6(3) of the Estate Acquisition Act. Thereafter, we pointed out that, my lord, our challenge is different from the two appeals which your lordship is hearing of Mr. Basu. Our point is different. So that's why your lordship said that. So it need not be tagged. It will be taken in the usual course.
no Mr. Bose, what happened that day?
My lord.
Arguments could not be completed
My
by
lord.
the state.
My lord.
So we have kept it on another day.
My lord.
Tomorrow.
I think it's today. It's in the list.
Oh, today.
54 and 55.
So today, if their arguments are concluded,
My
we will reserve our judgment.
My lord.
Now the thing is, next week my brother won't be here.
My lord.
We will be reassemble in the last week of February.
My lord.
By that time, if the judgment comes out,
My lord.
you consider that and then you make your argument in
Very well,
respect of-
very well.
And
Because
we will keep this matter along with those two matters of yours. That is already in the list today.
my lord,
So we
actually, my lord,
this is also somewhat similar.
no, it is not. My lord, our challenge to the order of resumption, the grounds of challenge are different from those argued.
Resumption is under challenge.
Resumption is under challenge.
এইটাকে না ওই যে আজকে দুটোর সময় যেটা
3 p.m. perhaps.
আচ্ছা তো তিনটের সময় আজকে ওইটাকে কি সিচুয়েশন দাঁড়ায় মোট কথা যেদিন নেক্সট লিস্ট করবে সেদিনকে এইটাও রেখে it will be there along with your matter which is the next one
Very well.
and whichever date is we fix after hearing them today on that day you let your junior keep track of this.
Very well, very well. My lord, only one indulgence, my lord. There is a subsisting interim order till the end of this month. May that continue. That interim order has to be
We
extended.
will hear it. It will in the last week of February we are
No, it is there. There's a limited interim order, so that needs to be extended.
It is still January.
Yes, my lord.
All right, we will do one thing. We will keep in the supplementary list on a particular date.
Mile.
All right.
Mile.
And if on that date, whatever is the situation, ask your junior to remind us so that we can tag it up with the other matters. All right, we are extending your insurance.
My lord.
বলে দাও hardly learned advocates appearing for the respective parties list the matter for further consideration in the daily supplementary list of this court on 4th March 2025. Stop. The interim order passed earlier is extended till the end of April 2025 or until further orders, whichever is earlier.
Wait.
For the petitioner, my lord. Personal lordship direction has served a copy of the contempt application. This is my affidavit of service. My lordship's order was at page 24.
Service is complete.
Yes, my lord, Mr. Kollan Chakraborty is appearing, I was told.
Where is Mr. Cho?
He appeared before your lordship in the writ proceedings. And I was inquired that Mr. Chakraborty is appearing in the contempt proceedings also. Lordship, so desire I can issue further notice to him or
What did we direct?
lordship directed because lordship the petitioner was a bungalow peon, my lord. Who lordship vividly remembers when petitioner's appointment was terminated
They
before
passed the
1 year.
order.
My lord, what they have done actually is this. My lord, lordship has directed and issued a guidelines within which they have to pass a speaking order, relying upon the circular at the time when the petitioner was terminated. Now, my lord, what they have done, they have said that the petitioner's case is overall guided by 2020 circular, which the circular which was not at all placed before the tribunal, neither placed before your lordship. All on a sudden, this new circular has come into existence and they have denied the benefit of appropriate consideration on strength of that. Ignoring all the observation guidelines of your lordship. My lordship was categorically stated, lordship has stated here, my lord. Kindly see the operative portion, which is at page 29. Page 29 from last paragraph, it reads that in the said, may I read my? Page 29 from last paragraph.
Page
29. My right was overall governed by the circular of 2010. And on that basis, lordship has directed them to pass a speaking order to by revisiting the same. They have not at all considered that, rather considered a circular which was not placed and agitated before your lordship and also before the tribunal.
They have not considered in terms of
Yes, my
9.
lord, kindly see page 59.
No, no, we asked them to reconsider on the basis of 9 June circular.
Yes.
Drop করা হয়েছে, page 6 এ।
Kindly page 59 is the operative portion of the speaking order. Last paragraph.
Yes, please.
My lord, may I please, my lord? My last paragraph, my lord. However, as directed by the Honorable High Court during personal hearing, all possibilities towards incorporation of your name in the reserve list has been explored and intimated to you that due to non-existence of the post of Banglo Peon, TADK, it would not be prudent to keep your name in the reserve list. It has also been explained to you that the engagement of TADK.
No, no,
erstwhile
read from the.
Yes, my lord. Next line, it will clear. Designated as Banglo Peon is discontinued by the Railway Board Circular 102 of 2020. And at present, there is no provision exists in the railway to re-engage TADK. This was never stated before the tribunal. I didn't have the opportunity. Now, for the very first time, my lord, they have used this circular to negate my claim.
Where is the order?
Order is at impugned speaking order, lordship.
No, no, come to page 29. What we ultimately in the said conspectus.
Yes, in the said conspectus, we are of the opinion that the competent authority ought to have considered the petitioner's claim in the light of provision of 3C, 3D, and 5B of the circular dated 9th June 2010, together with the provision of IREM for re-engagement or for incorporation of his name in the reserve list from wherefrom he may at least get an opportunity to be considered for engagement in the exigencies of administrative requirement. The learned tribunal had rejected the petitioner's claim and had affirmed the order dated 26 April 2016 being oblivious of the provision towards re-engagement and incorporation of the name of a substitute Banglo Peon as provided respectively
Now
under.
tell us, in the 9th June circular was directed to be followed. And
they have negated on the basis of 20th.
No, no, what is this 26th order did we set aside?
Yes, lordship has set aside the order of the tribunal and directed the authority to
Now,
give his.
this 26th April 2016, which you challenged before the tribunal, in that which circular was taken into consideration?
The consideration was taken of the 9th June. 9th June 2010 circular was taken into consideration.
Now show us the order which has been passed.
Kindly come to page 59. 59, last paragraph. They are negating my on the basis of a circular.
Page 59.
59. This is a impugned speaking order. Lordship, kindly see last 3-4 lines. It has also been explained to you that the engagement of TADK erstwhile designated as Banglo Peon is discontinued by the Railway Board via RBA number 102 2020, and at present there is no provision exists in the railways to re-engage TADK. As such, even if your name is maintained by creating the live register for you, there is no possibility of a re-engagement. I am putting this question to myself, my lord. If this provision would have been highlighted before the tribunal and before your lordship at the time of when the matter was argued, I would have an opportunity to at least place relevant citations that the game of the
102 was placed.
This was not placed.
102 of
Never placed.
2020.
Lordship will see from the order. This was never placed. Neither placed before the tribunal.
Due to non-existence of the post.
But my say,
it would not be prudent to keep your name in the result list.
I could have understood, my lord, that
it has also been explained that the engagement has been discontinued by Railway Board circular dated such and such.
I was not aware. I was all along proceeding with the litigation on the strength of the circular which was there when the termination was effected. And my right crystallized under that circular.
আমরা সেই জন্যই আমরা বলেছিলাম যে সেটা বলে তুমি রিজার্ভ
লিস্টে রাখো, হ্যাঁ যখন দরকার হবে তুমি নেবে, কিন্তু ওদের ইয়ে হবে
রিজার্ভ লিস্টে
এখন there is no post existing.
মানে subsequent promulgation
অ্যাপিল করে give a further notice.
Yes, I will. I will. My lord, lordship is
Then
well
it has
aware.
to be, then we will consider what is there.
Subsequent circular cannot take away my right, which has crystallized under the
No,
circular.
no, they are saying that today, if you are kept in that list also, there will be no scope for your regularization in future.
Lordship, they could have said it before your lordship. By saying this circular, highlighting this circular, that it exists and it takes away my right.
So where is that circular? Have you annexed
No,
that?
I was
RDE
not aware.
10?
I was all along pursuing my legal remedies on the strength of the notification of 9th June 2010.
So your contention is that they did not argue
Yes.
this 10.
Tribunal did not have the opportunity to deal, neither I, because on,
Neither of you, that this post is not at all exist.
I was all along of the that this post exists on this circular, and I pursued my legal remedies for enforcing. But I was never told, neither they have filed any affidavit before the tribunal, neither.
In the order of rejection of 26th April,
Yes.
what did they say?
They say that, my lord, as lordship has set it aside. I'm
26th April, যেটা ওকে রিজেক্ট করেছিল without citing 10.
ওদের রিভিউ করে
Yes.
তাহলে আমাদের অর্ডারটা কি
Well, may I read?
What is it?
Yes.
এক্সারসাইজ রাখতে বলবো তার জন্য একটা রিজার্ভ লিস্ট প্রিপেয়ার করতে
তোমরা যদি ক্রিকেটের মধ্যে প্রভিশন এখন আর্লিয়ার অর্ডারটা যখন ক্লেমটা তো ছিল নট ফর প্রপোজিশনাল রেগুলারাইজ করে শুনতে হবে।
My lord, nothing has been said here.
It has to be hard, Mr.
My lord, kindly see the order. Nothing has been said of this circular. If this was issued,
then you could have brought it to our.
I was not aware, my lord.
You are a seasoned person arguing.
I was not there before the tribunal, my lord. 2020.
So maybe Mr. Roy, you could have pointed out at least, or we could have dealt with that aspect.
Well, it was the responsibility because the railway has come out with this circular, my lord, at the speaking order.
Did they use any opposition?
In the opposition also, my lord, they have stated nothing about it in before the tribunal. That's because the tribunal has not dealt with this particular circular. Now, this circular has been taken into confidence in the speaking order.
Give a notice to.
I will give a notice.
Day after tomorrow.
Grateful, man. Affidavit of service. Acha,
Your Lordship, I am on behalf of respondent number 224, Your Lordship, GTA. Before Your Lordship takes up the matter, Your Lordship, I am praying for a leave to file my written this thing, Your Lordship. Opposition, Your Lordship. I haven't filed because till date it has not been heard that way, Your Lordship. So I'll file opposition to the stay application, Lordship. At least there should be something on the record. Although matter is very small, Your Lordship, it's very.
So did we direct you to file any opposition?
No, it has not been not given any, Your Lordship, till date. So
you appeared earlier.
The matter was extensively taken up by my lord, your lordship's coordinate bench. Matter was extensively taken up. Mr. Subba's client is for the Gorkhaland Territorial Administration.
That is 224A.
Yes, Your Lordship.
The substituted respondents, earlier respondents have merged into the Gorkhaland Territorial Administration.
So your can one is, what is your can for stay?
Can, my lord, is for stay for a given purpose. Yes, stay and injunction.
So
the reason is.
Did you use any opposition before the trial court?
Trial court I have used.
You have used?
Trial court.
Or you were not there at that juncture?
No, I was there, Lordship.
No,
it was extensively heard, Your Lordship. It was extensively heard.
Now the trial court, my lord, devised a three-pronged formula.
Only thing, your lordship, which I want to take the point here is the point of maintainability.
No,
your lordship.
whatever.
So
Point.
that
Now,
is why
now he's taking a point of maintainability. He may
because
yes.
till date
Was there any earlier direction for affidavit?
in the stay, perhaps no.
No, it was
Perhaps
not. That is why, lordship.
Point number 2 and 3.
No, your lordship. Two to four, all except one, your lordship. Yes, lordship.
Gorkhaland Territorial Administration has taken my land. The honorable trial judge said a part of the land has been is apparently used by them, required by them. The remaining part is not required. The remaining part, the learned trial judge said, should be returned to me. And because the remaining part and the part which they require have not got any proper navigable connection, so the learned trial judge, at their instance, gave them an option to which they agreed and said they will be building a road or in order to connect the land which they are taking to with the land which is there in the remaining part. Why this thing is coming up? Because it's not a plain land; it's a hill land. So if it's a hill land, the part which they take, the remaining part becomes inaccessible. So for that, the learned trial judge devised three options and gave them a choice. Option 1, give back the land because you have not yet acquired it properly. Option 2, acquire that part which you say you need, and the balance part, which is larger in area, give it back to them by connecting a road in between. And option 3 is acquire the entire land. They chose option 2. That is, we are going to give back the remaining larger portion of the land, but we will build a road. Then the learned trial judge, my lord, gave them at least 15 opportunities to come up with a proposal. Initially, they were bringing, my lord, handwritten sketches without any, my lord, dimensions.
So if they give you that portion, the road construction, they have to make.
They agreed for that proposal. There were 3 proposals, my lord. Why am I aggrieved? I said these 3 options that have been given to them, they are, it's actually, with great respect to my learned friend, will give the chance for a cat and mouse game with his client, because what they will do is these road construction, they will just show a red herring. They will not do the road construction and they will keep this entire order on hold. Therefore, I said, I am the land loser. Option should have been given to me which one to be exercised, not to him. He is in illegal possession of the entire tract of land, having entered the same without authority of law. I am entitled to get back.
Lordship, the total,
Now, Mr.
total
Subba
land.
said his client, then before the coordinate bench, when the matter came up, Mr. Subba's submission was that his client will compensate us, I mean, buy out the land from us. I said, I have no difficulty. You please give me a rate which my client will accept. Buy it out consensually. There is no difficulty. But you can't impose your rate on me. That took another 10 occasions for Mr. Subba's client to respond. Then they came up, my lord, with a governmental a track report showing the circle rate of the adjoining place and say that for that purpose, we'll give you equal to that circle rate. According to us, that is not a feasible compensation for the purpose of that.
Then
Consensually.
What did the trial judge
Learned judge was ultimately wanting further instructions to be taken by Mr. Subba's client as to how to go forward in the route.
Why have you come up in appeal?
I have come up in appeal because according to me, I should have been given the right to choose out of the 3 options, not him. And I choose return. They have not yet used any part of the land for any purpose. Some point of time, they said they'll be constructing a reservoir there.
That's a very good, Mr. Banerjee. We will remand it to the court below. We will reject their option. You try it out.
No, your lordship, there are 3 options. I tell you, lordship. Already, my lord, there are 50.
That none of the options they chose one option, but they failed to do so.
Yes.
Now, if they fail to do so, you are entitled to the rest of the land.
I'm entitled to the entirety of the land.
Then go to the trial judge and say that.
My lord, your lordship,
decide that.
Your lordships can give me that. You see, here, there are 3 options. I am entitled to my land.
Lordship, I'll make my submission, Lordship.
Now he comes and
little
says he challenges maintainability.
The facts are a little bit different here, Lordship, I think.
Mr. Subba,
Lordship, what has happened is, my learned friend's client, he had, your Lordship, 4.80 acres of land, your Lordship. And the Darjeeling Gorkha Hill Council, at that time, your Lordship, they needed land, your Lordship, for making a reservoir, water reservoir, Lordship. And water reservoir had already been made there, your Lordship. And for that 0.80 has been used. It is not that the land is lying there unused, your Lordship. So when the matter came up before the lower court, your lordship, in the learned single judge, your lordship, the statements were made, your lordship. The arguments were done, and at last, your lordship, three options were given. And at that time, my learned friend didn't submit anything, your lordship. He agreed to that, your lordship. Against that, he should have come for appeal, your lordship. He did not come. He did not come, your lordship. He came against the last order, against which there is no appeal lies, I think, your lordship. That is my case, your lordship. And according to their own letter, lordship, we have used only, lordship will kindly come to their letter once, your lordship. Their advocate says to the first letter which they have sent, your lordship. It is page 105. This was the first letter which they had written, your lordship. Briefly, to refresh your memory, the grievances arises from dismantling of the wire fencing post so-and-so of a reservoir complex by Kalimpong Engineering Department at Sherpatar, Kalimpong, by occupying 1.20 acres of our valuable and comprising a total area 4.80 acres of registered ownership company had which entire area bounded and widened fence, etc. Next page, your lordship. We have never used the total land, your lordship. We have never used the total land. Now, your lordship, kindly come to, yes, your lordship.
Yeah, compensation.
No, we have already given the rent, your lordship. Rent for the entire land. For 23 years, we have already given them. They have already accepted that, your lordship. They have received that. Now, only what remains is the compensation for the land, your lordship, which we have taken now. Only that remains, your lordship. And we have to make the road. Excess.
Considering internal pitch for the last year of the last year. 2 to 4 inches submission made on.
Lordship will kindly come to next page, your lordship.
Determination release of.
Yeah, determination.
The Mr. Banerjee,
next page, your lordship.
Come to the last page of the order. This penultimate pair, considering such submission made on behalf of the petitioner, as you are saying that the compensation was inadequate. You said, now the court said that we give you leave to take steps in accordance with law for determination. Now, who will decide?
No, there are two aspects. One is they were illegally on my land.
We have understood.
So one part is determination of compensation. One part is determination of compensation for the period that they are in illegal occupation.
Yes.
Second part is acquiring the land if they want to keep it because they have entered without authority of law.
That?
Yes, that is there.
That you acquired the land?
They didn't acquire the land. They didn't acquire the land. That is the brass tacks of the matter. Everyone is admitted that. In 2003, the Darjeeling Golkha Hill Council, bear with me for
where you are, which portion you are aggrieved, sir?
In the order, by the order. But by the fact that this has been accepted, kindly see, my lord, page 177. This is the final order. My lord is seeing the stay application. My final order, my lord, internal page 1. May I just place, my lord, only an extract? Pursuant to the order passed by this court, today an affidavit has been filed on behalf of Gorkhaland Territorial Administration affirmed by such and such on 18th April, which is taken on record. On perusal of such affidavit, this court finds it proper to quote paragraph 5 herein below. I say that it will take 9 months' time for construction and completion of the alternative road / thoroughfare for the remaining land of the petitioner near the Capsule Lake, Kalimpong 1 block by the Kalimpong Engineering Division of Gorkhaland Territorial Administration. It is to be noted herein that in the order dated 21st November 2022, this court gave 3 options to the Gorkhaland Territorial Administration authorities as well as state respondents, which are set out below. Number 1, to retain / acquire the entire 4.80 acres of land of the petitioner.
Skip that portion.
Now, it is also recorded in the previous order that the concerned respondent authorities opted third option amongst the 3 aforementioned options given to the authority. Pursuant thereto, a detailed plan has been submitted before this court for construction of alternative approach road to remaining 4 acres of land at Kalimpong Industries Private Limited near Capsule Lake, Jorpokri at Deolo, Kalimpong. Now, my lord, page third internal page. Having considered this detailed plan submitted on behalf of respondent authorities, this court wanted to know from the learned advocates representing the respondent authorities the time to be consumed for construction of such alternative vehicular road, which would give passage to the petitioner from the nearby PWD road to the said 4 acres of land of the petitioner. And this court directed the Gorkhaland Territorial Administration authorities to file an affidavit disclosing such time. Pursuant to such direction passed by this court today, an affidavit has been filed and it has been averred in paragraph 5 of the said affidavit that the concerned respondent authorities will require 9 months' time to make construction of alternative vehicular approach road to remaining 4 acres of land of the petitioner. Having considered this affidavit and statements made in paragraph 5, the writ petition stands disposed of by directing the concerned authorities of Gorkhaland Territorial Administration as well as the state respondents to complete the construction of alternative vehicular approach road, which could give vehicular passage to the petitioner from the nearby PWD road to 4 acres of land within a period of 9 months from this date. It is also required to be noted here that pursuant to the order passed by this court on 8th of December 2022, the concerned authorities of Gorkhaland Territorial Administration has already paid 22,25,588 to the petitioner towards rent compensation for retaining the land in question from the year 2003 onwards. However, due to exercise of the third option, 4 acres of land stands released from the possession of the respondent authorities in favor of the petitioner, and the petitioner shall be free to enjoy the ownership and possession of the said 4 acres of land. However, on behalf of the petitioner, submissions have been made that such compensation.
So you were directed leave to take
Yes, to
steps
challenge the quantum of compensation. Second is acquisition. What about acquisition?
You should have filed a contempt, Mr. Banerjee, because that portion of the order regarding alternative vehicular route, that court has already directed in your.
But the court has not told them to acquire it.
Forget about it. When you go and contempt that they have made an undertaking before the court.
Yes.
Your problem will be solved if this connection is made. You will get access to that land.
My lord, my prayer was before the authority, before the court, please give me back my land. The entire land has been entered into without.
That has subsequently been
used for the purpose.
That has subsequent boiled down to the portion of option.
Boiled down to the option for them.
Right. Now the option they failed to exercise, or whichever they wanted, court negated and said that no, you have to stick to this because earlier you have opted. So court said that you complete it within 9 months.
Yes.
So if this aspect has to be thrashed out by you in contempt.
But there is another part about which I am aggrieved. That is, what happens to the land that they have already taken up? They have to acquire it.
That you can seek appropriate direction
from where?
The court.
From the honorable
that
court.
You cannot imagine just now having
they have not acquired. My lords, they have not acquired yet.
This non-acquiring of the land has boiled down to the exercise of option. That how the matter can be solved.
Matter could have been solved by this. They would still have to acquire.
You also have changed your stand subsequently. All right, we will be satisfied if this option is
my lord, subject to my lord's correction, please have a look at all the earlier orders. I have placed them. There is not a single place in which I have said I accept.
No,
they are going paying rent compensation to you.
No, they had whatever they had to pay rent compensation. My lord, I barge into this gentleman's house, land, and I start using it. There are 2 liabilities for me as the state. Number 1 is I have to, if I've done that without authority of law, I have to give it back to him. Otherwise, I have to acquire. That is for acquisition to gain title. In the meantime, without getting title, if I have used it over a period of time, then you have to pay without prejudice to that acquisition part, rent compensation. This rent compensation, 22 lakhs and odd, the learned trial judge directed them to make after much ado. Then they ultimately paid that rent compensation to me, which I have accepted. Learned trial judge has given me the liberty to challenge the adequacy or otherwise of that rent compensation before an appropriate forum. I am grateful. Learned trial judge has made 3 options. Option 1, give back entire land. Option 2, acquire entire land.
And you are repeating your submission.
So my lord, the last
challenge before the writ court was as regards acquirement and acquisition, which you are arguing now.
Yes, regarding barging into my land without acquisition.
Right. considering your arguments and their arguments, court directed 3 options.
Yes.
Now you are saying that none of the options I am going to accept. Now you determine why it was acquired at all.
Lordship will kindly give me any option, please, my lords.
Right, but it was
Who is the person who's entitled to who's entitled to exercise option? Please bear with me. Who? Me. Me.
21st
It's my land.
21st November, your arguments were extensively quoted and it boiled down to the direction for this option.
No, please see, Milord, the 23rd November order. Please see, all the orders have annexed. Milord, all the orders have annexed.
Lordship will kindly see the prayers, your Lordship.
এক সেকেন্ড সুব্বাজি
ঠিক আছে এক মিনিট সেটা করে দিই
এক সেকেন্ড
সেটা তো সংটাতে কোর্টটা তৈরি করে দাও 9 মাস আগে
Lordship will kindly see the prayers in their writ petition.
All the orders, I was not given an option.
Actually, title is still with you.
Yes.
Lordship, prayers in
They
the
are
writ
in
petition.
occupation.
Interland.
Interland.
They have used 0.8 acre land. They have used, but not as yet acquired.
Not as yet acquired.
So they are paying rent compensation.
Yes.
If they stop rent compensation, then you will come and say that they have stopped payment of rent compensation. So either ask them to pay compensation or to acquire.
I'm grateful to Lordship. Grateful to what has fallen. There's only just one rider to it. This rent compensation is not consensual rent compensation.
Yeah, understand.
This is kind of a damages for illegally occupying for that long. That quantum they have paid up to date under orders of court. But that doesn't entitle them to perpetuate their use. To perpetuate their use over even that 0.3 acres, they have to acquire. If the learned judge says build a road, told them to build a road, they said I will build a road after 9 months. I am not concerned. I am saying if you do not acquire whichever part you need, there can be no other orders made. Therefore, no option was given to me. 3 options given to authority. Authority thought I will take the middle path. I asked the petitioner, kindly in none of the orders. My lord, I can understand what queries are passing to your lordship.
You are getting the rent compensation now. Are
No,
they paying?
No. That was a one time.
Oh, your Lordship, we were ready to acquire the land. They have come up in the appeal, your Lordship. Then appeal court directed me to get the
Subba is making
new, no, your Lordship,
with
new
great
valuation
respect.
order is there, Lordship.
I just hope I will.
Valuation I've done that also, your Lordship.
If I could have shown your lordship, the video recording of what transpired before the coordinate bench, my lord can see.
So they
Only thing, your Lordship will kindly see their own writ application, Lordship.
Let them acquire under land acquisition at 2013. That is something that they have to do.
Writ application, your Lordship. Writ application, Lordship. Lordship, you kindly come to page 65 once, your Lordship.
Come with your opposition.
Now, in the name of this 9 months, this 9 months suspension, what they are doing is nothing. I will build a road. They are showing 2 papers. I will build a road. They don't have funds.
Mr. Subba, within which period you will complete the preparation or
Immediately, as soon as your Lordship gives the direction, Lordship will pay them.
They
are not
have any
accepting.
money.
They are not accepting the money, your
They
Lordship.
don't have any funds. And what they want me to agree to, whatever measly funds they give, they have to acquire in terms of the 2013 Act. How can I take whatever little money they want to give me?
Till the acquisition process and award is made, they will go on paying rent compensation.
Let them acquire immediately. Otherwise, give back my land. Otherwise, give back my land. This road thing, my lord, why they have taken.
Government policy, your Lordship.
You put down in the affidavit that you will acquire the land.
Yes, your Lordship. That is why I said, your Lordship, yes.
You are short affidavit that you will acquire
I'll
the land,
that, your Lordship.
and on that basis you are not being able to do so due to pendency of the appeal, and he will be satisfied. We will set back a time period within which he can.
Very well, Lordship. Very well, Lordship.
Yes.
And the road.
I am saying otherwise give back the land because none of the options of those
Road,
three
your
was
Lordship,
given to me.
we have already given it.
My lord, if the state takes my land,
already
options have to be given to me to decide which is the road.
Road about
State
Tenders
can't
have
give an
already
option.
been given, your
If I don't
Tenders
accept.
have been given.
road you have
Tenders have been
Tenders
given,
have
your
not
Lordship.
seen the light of
Yes,
day.
your Lordship, everything, your
This is
Lordship.
the
But they have
red
come for
side.
appeal.
wait,
Oh,
you want some.
But they have come up for appeal, your Lordship. That is why we could make
Float
it, your
the
Lordship.
auction. When
Yeah.
did you float the auction?
It is, your Lordship.
They don't have money. Ground reality, if they
You,
don't have
Mr.
money, they are not
Subba,
putting
Yes,
tender.
Your Lordship.
It's
you
only a red herring to show to court.
you disclose your stand as requires
Yes, Your Lordship, I'll
acquisition
add
of
that
the
now.
land. And you disclose that you have already taken follow-up steps in terms of the single judge's order towards that construction of the road. Put
I'll
it
do
on
that, Your Lordship.
affidavit. We will bring it on affidavit and dispose of the application.
Very well, Your Lordship, very well. Lordship.
The present application being can
And one.
1 of 2023 has been filed Next matter.
Read file near. My lord, would your lordship call for the read file? The read file is not here, but that will perhaps help everybody, including me.
No, read petition is there.
Read file, the read file, the records of the read.
Ask your advocate on record to check it up from there. Yes, next.
Well, in item number 20, my lord, I'm praying for 2 weeks' time, my lord. Pursuant to your lordship's direction, my lord, they have served supplementary affidavit on last
We have prepared,
Friday,
let
my
it be
lord.
kept with the record, my lord.
Learned Advocate General is appearing, my lord, in this matter. 20, item number 20, my lord. 20.
You have filed a
Yes, my lord,
supplement?
just now, my lord, I have.
What is that? Informal paper book. Paper books we recorded, it has already been filed.
That has been filed by the
Oh,
Pursuant to your lordship's
subsequently, my
direction.
lord, supplementary
filed a
paper.
supplementary paper.
Supplementary, my lord.
That matters.
Yes, my lord, let it appear, my lord, on in the month of February.
Forest land.
Private forest land, now they are claiming it is under the Indian Forest Act. February, my lord, any date.
Mr. Banerjee, learned advocate appearing for the respondents, files the supplementary paper book. Files the supplementary paper books. Let the same be kept on record. A copy of the same has already been served upon the learned advocate on record of the appellants.
Yes.
Today, however, an adjournment has been prayed for on behalf of the appellants. In view thereof, list the matter for further consideration in the daily supplementary list of this court on 26th February.
My lord. Good.
My lord, item number 21, my lord, I am for the land loser claimant. My lord, 21 and 22,
Both are arising out of the
same plot of land,
my lord, I am in
common
this matter, my
judgment.
lord, I am led by the learned advocate general.
No, you are the respondents in the appeal.
Yes, yes,
And the other appeal has been preferred by?
requiring body.
Why
Both,
to appeal?
Because two writ petitions in respect of common plot of land, one is the vendor, another one is the vendee, and the vendor has had 26 decimals of land, vendor sold 22 decimals of land, so both are claiming compensation. One is for 22 decimal, another one is for rest of the amount 4 decimals.
That was hard together.
Yes,
Yes.
yes.
This was hard together.
Paper books have been filed.
No, paper books.
No, last occasion, my lord was inquired whether every papers are there. We said yes, every papers are there.
Yes, start then. What is it?
My lord, in this matter, my lord, learned advocate general is.
You talk with me. We are every day facing at your insistence.
He was supposed to. Yes,
No,
he was supposed to
Mr.
do this
Talukdar,
matter.
you talk with Mr. Dhar and tell us.
And
This
if he
way, this
opposes, then
cannot
I have
continue.
to start. That's all. He was supposed to come today. He has not engaged in other court. That's the problem.
The appeal was about to be dismissed in the coordinate bench. There, my lord, after 2 days, 2 days, and the bench had expressed that we are going to dismiss the appeal.
That is, you may submit so.
At the last
We have-
round.
2 weeks. Yes, next.
The client is after me. Every day client is.
Mr. Talukdar, this becomes a bit embarrassing.
this-
Your advocate general, it won't be possible for him to appear in all the courts. You have to take it up, Mr. Talukdar. You are quite senior.
Fix
If
করো না,
you
তুমি তো
come and
বললে একটা
make a
date
prayer
fix
for
করো।
adjournment, it becomes embarrassing for the court now
Hello,
because
sir.
we are deferring. You please
Yes,
get
yes.
ready.
I
Start
also.
your argument. At least we can proceed somewhat.
If your lordship, if your lordship so
Please,
desire, my lord, I can.
we have adjourned it for 2 weeks. You speak with
Or-
your advocate and tell Mr.
Yes, yes,
Dhar that we will be.
yes.
Then at least or by the time we are fixing matters at 2 p.m. so that we can dispose it of.
Right, right.
Part hearing gives nothing to everyone. Again hard, again to be hard again. What
Plus, personally, I am also feeling
Yes, next.
embarrassing.
করবে না, তুমি
Fix. Kindly record today's at least. I could so that I could show my client.
That will be embarrassing for you, Mr. Dhar. We made it last chance only on the last occasion.
I'm for the writ petition or respondent, my
I'm for the appellant, my lord.
I'm sorry, my lord.
Yes, Mr. Ghosh.
Your lordship, to cut short the matter, your lordship kindly takes up my supplementary stay application, my lord. May I point it out, my lord?
This is mandamus appeal.
My lord.
You are for the state.
I am for the state. It's my appeal, my lord.
What did the trial judge say?
My lord. My lord, to refresh your lordship's memory, my lord, the first allotment to the petitioner was made in the year 1999. My lord, soon thereafter, a PIL was moved. And my lord, pursuant to the order passed by the Honorable Division Bench, my lord, that allotment was cancelled since, my lord, that particular plot was earmarked earlier to build up a gallery or something like that for public purpose. Next proposal, my lord, your lordship kindly comes to my page 6. Page 6 of my may I read it out, my lord?
Page 6 of your
my supplementary stay application, my lord.
So before you go to that,
My lord.
kindly come to the order impugned. What was the direction?
My lord, my lord.
Allow the writ petition by quashing the 27th May 11 order passed by the estate manager and directing the respondents to give effect to 24th August 2010. That is the earlier decision.
My lord, may I be permitted to justify, my lord, why that order could not be persuaded? My lord, it is to be mentioned here that
page where you are
page 6, page 6. Para III. It is to be mentioned here after the cancellation of this allotment order of land at the western side of the DC building, no further plan of allotment of any other land was received from the petitioner Kollani for consideration. Instead, the petitioner filed a writ petition being so and so, and in pursuance of the Honorable Order High Court dated so and so, a reasoned order was passed by the then estate manager 24/8/2010 without concurrence of the Urban Development and Municipal Affairs Department, Government of West Bengal. Now, your lordship kindly takes up the annexure, my lord. Page 32
of the
supplement. Page 32, annexure P7, dated 22nd May 2006. The government has been considering for some time past, the legible printout is in page 34. Page 34. It has been typed. Residential, the government has been considering for some time past the question of labored down guideline for allotment of vacant plots and built up houses belonging to the Development Department of Coal Township. Now, after careful consideration of the aspects of the matter, the governor has been pleased to formulate the following guideline for allotment of vacant and built up house at Kollani. Your lordship kindly turns to page 35. 4.4. Industrial commercial plots, the plot of the petition. Page 35, the type copy.
Yes.
Applications for allotment will be received by the estate manager Kollani and examined by the committee constituted with order so and so on case-to-case basis on the merit of application after due assessment of then activities, financial strength, capacity to generate employment as well as audited accounts for proceeding 5 years and article final decision
on each application will be taken up by the Urban Development Department on consideration of the recommendation of the said committee. So, my lord, the order impugned was dealing with only a proposal in terms of the notification dated 22nd May 2006. It was never a allotment at all. It was only a proposal subject to which, my lord, the Urban Development Department was supposed to sanction it, being the final
upon formulation of a scheme.
My lord. And, my lord, as far as this proposal was concerned, my lord, that plot was also earmarked for some public purpose, my lord.
No, are you meaning to say that clause 4 has to be read with the first paragraph?
My lord.
So no such scheme was formulated by Kollani Estate?
No, my lord. As on date, my lord, pursuant to the spectrum, your lordship
Now
kindly
let us please to formulate the following guideline for allotment.
My lord.
So you are under obligation to follow this guideline.
My lord, but my lord, the plot under reference with the estate manager has indicated that has also been earmarked for some public purpose. Kisher jonno? Library. For
Mr. Ghosh, you are saying that this as well as order for preceding this industrial commercial plot will be how it will be allotted, that has been given in paragraph 4.
No, this paragraph 4 is the after considering those particular facts and circumstances, the estate manager can recommend by the final decision, as it indicates, final decision on each application will be taken up by the Urban Development Department on consideration of recommendation from the state committee. This committee is only a recommending authority.
Now, who are the persons in those committee?
This is the estate manager
and others.
And others.
Achha, very good.
This
now,
is only a recommending authority.
After this, what happened?
Your lordship, page 7, my lord.
7 of the supplementary.
My lord. V. My lord, pursuant to the 2G spectrum decision, as your lordship knows, my lord, now the present land allotment policy 2012 issued with a so and so came into force on 26/12/2012.
That is page 34 was negated.
My lord, your lordship, it is in page 40.
No, that is in supersession of the earlier policy.
2006 notification.
Now you are showing us page 40.
Page 40 is the my lord?
New scheme.
My lord. The new scheme. And my lord, your lord can come to page 36, my lord. Page 36 for once. Page 36. Page 36. Point 3. Now the governor, after
Point 3.
Point 3. Page 36, annexure P8.3. Now the governor, after clear consideration of the matter, is pleased hereby to make the following land allotment policy, which will be applicable to land owned by, held by any department of state government or agency funded by the state government of any manner. Your lordship kindly comes to page 37. Fourth line.
Which will be applicable
land meant for commercial uses.
Page 36.
Page 36.
Governor, after consideration, make the following land allotment policy, which will be applicable to land owned
or held by
any
department of state government or agency funded by the state government in any manner.
So you are the
Urban Development Department, my lord, funded by the state government.
No. This how it will be applicable to you?
Because the land actually belongs to the Urban Development Department, my lord.
You are appearing for whom?
For state, for the state, the Colon estate manager, for the state, my lord. My lord, for the estate manager as well as the Urban Development Department.
So this policy will be applicable to you.
My lord, your lordship kindly comes to page 37, my lord. IV. Land meant for commercial use shall invariably be auctioned to the highest bidder for which adequate, this has been followed in the 2G spectrum decision, my lord. The decision in non-propriety has been passed in February 2012, my lord, and thereafter this policy decision has been taken by the government, for which adequate publicity should be given, including through the internet commercial use, will mean use for office, shopping malls, housing, not mean for so and so, schemes, hospitals, education institutions, and would include all activities except those activities for which a different mode of deposit is prescribed. Now, your lordship, page 38. Project proposal for private education institutions and medical facilities, the petitioner's land, my lord, will be deemed to be commercial ventures, except where such projects are to be set up by the public charitable trust, so and so. Now, my lord, your lordship comes to page 39. Page 39. In the event of special circumstances, the government may, with the intention to protect and promote specific activities, or to promote any emerging areas of development activities, or to reduce imbalances, any such, especially beneficial to state, may, with the approval of the state cabinet, may, with the approval of the state cabinet, relax any or some of the above mentioned criteria. The sponsoring department will be required to prepare cabinet proposals in a full extent or relief of the jurisdiction. So, the crux of matter is that, my lord, the order passed in 2010 was a mere recommendation by the estate manager, and, my lord, in the light of the memorandum 2006, the final decision is to be taken by the Urban Development Department. And, my lord, while Urban Development Department, my lord, they have found that land also was specified for public purpose, my lord.
No, you took the decision.
You haven't taken any decision, just only a
They went to
recommendation.
court.
Recommendation.
Show us that. Show us that.
My lord, it is there.
Because the initial decision was 2006.
My lord.
After that, the new land policy came in 2012.
My submission is that, my lord, that was only a recommendation made by the
Which was the recommendation?
2006. The order passed by the Honorable Single Judge.
No. This when did you your first order was 20th of, which was referred to in the
2010.
Where is that order? 2010. First order was of 2006. In the last paragraph of the judgment, the court says that your decision of 27th May 2011
No, that was
is
not
quashed.
That was not 27 May 2011. This order was quashed. This particular order was quashed.
So this was quashed,
my lord,
by the single judge.
My lord.
So this has not
speaks,
been.
my lord, somehow, my lord, because this speaks about the utility of that particular plot, which was recommended to the petitioner only, not allotted. Because estate manager was not the authority to allot any plot of land.
Contrary to the master plan.
Contrary to the master plan. Administrative decision, my lord, cannot override the master plan, as your lordship knows. The master plan speaks about this utility pertaining to the plot about which the petition has approached the Honorable Court.
Honorable trial judge সেটা বলেছে।
Page
7 order.
And if your lordship kindly comes to page 7 of the order sheet, my lord, it was observed by the court that the order would not prevent the authorities from undertaking the change of the master plan so long as the present master plan survived. The change of land could not be made by an administrative order.
Where you are reading?
The order, the impugned order, page 7,
Honorable trial.
passed by the Honorable Trial Judge, middle portion. It was also observed by the court that the order...
Just a moment. Page?
Page 7, internal page 7 of the impugned order.
Where have you annexed the impugned order? In the stay application?
It is in the memo.
Paper book is there.
No,
paper book আছে?
No.
Yes.
Paper book হয়নি, paper book হয়নি.
Memo time.
Paper book is with us. Your lordship can make it handy.
Paper,
Hide করিস নি কেন? Paper book, I have been provided with the paper book.
They have prepared the paper. No.
yeah, have you got a copy? Of
No. No, order ছিল না তো আমি রেডি করে রেখে
তাহলে আমাকে
There
দিয়েছো
was
কেন?
no such order, Milord, that has not been handed. Milord, with that as the name, Milord. So, Milord, the bone of contention is that, Milord,
থাক থাক।
the order impugned. Order impugned.
সবার জন্য সুবিধা।
The order impugned deals merely with a recommendation made by the estate manager. And the particular plot of land.
Mr. Basu would be placing from the paper book, na? That will be easier for everybody of us.
Supplementary এটা নেই তো আমার।
Supplementary affidavit is not on the paper book. Well, I am opposing the papers filing of supplementary affidavit also.
Milord, the order to grant the supplement was passed in the presence of all the parties. It was a
Mr.
conference
Basu,
order.
you have used any exception to that supplementary?
No.
Your contention is that cannot be seen by the court at this stage.
My lord, unless it is 4127, my lord, can it be looked into by the court? There are paraphernalias where it has to be granted.
Let the informal.
Even if my lord peruse that, I can argue my case on the basis of this document also.
Let the informal paper books as filed on behalf of the
Order was passed.
Supplementary paper book is not there in the paper book. Supplementary affidavit.
No, we will take your exception and decide.
একটা কপি দেন গো।
তার একটাই আছে দাদা।
দেন একটা কপি দিন।
নেই আর কপি নেই। একটাই আছে আর।
পয়সা নাও একটা কপি করে দেন। করে দেন একটা। Lord, kindly direct them to give us 2 copies, Milord. 2 copies of the paper book, Milord. করে দেবো বাবা, প্লিজ। আচ্ছা ঠিক আছে, পরে দিস। গ্রেটফুল ভাই।
Document কেন ও এখনো একটা বাজেনি তো। পরেরটা ডাকুন কে আছে?
Lord, I appear on behalf of the petitioner.
I am appearing for the state, my lord, led by my Manal Senior Mr. T.M. Siddiqui.
What is the issue, Mr. Van?
A very short issue, my lord. I have lands which I have promoted, and those promoted lands, flats have been developed. I have put the purchasers in possession. This was in respect of various portions in West Bengal, including certain portions which are outside the purview of the Land Reforms Act. by virtue of the same being urban agglomerations. Now, my lord, I have done these constructions. At that stage, suddenly, my lord, a notice is given to me, my lord, that I hold excess land higher than 14M, and therefore 14T3 and 14T5 are proceedings are initiated against me. The entire lands are made to vest. I go before the authority, lose there. I go before the first appellate authority, lose there. The tribunal affirms the order, and then from there I have come. And before your lordships, my lord, after admitting naturally an order of status quo is there. Now, after that admission, there have been at least 10 instances where the matter has come up before, my lord, earlier the coordinate bench and now this bench. Before the honorable coordinate bench, there was a direction that I give full particulars of the persons in whose favor I have dealt with the flats. That I have given by way of a supplementary affidavit. And how much I have purchased and how much I have sold, so that from there the difference can be made.
Paper book হয়েছে নাকি এটা?
At the relevant point of time, my lands were much below 14M. It's a matter of arithmetical calculation.
হয়নি?
Twice, my lord, I'm told that Mr. Siddiqui was appearing. Earlier, Mr. Supratim Dhar was appearing. Both of them were appearing
Mr.
together.
Banerjee, are there paper books in this?
No, paper book direction to হয়নি। হয়েছে? Direction হয়েছে? না, না, আমার কাছে
You filed a supplementary affidavit in the appeal.
in the appeal pursuant to directions of the honorable. Supplementary affidavit
Why
containing
don't you bring it in a paper book? That will be convenient for all of us.
And my predicament is, I believe
Status quo.
status quo, and the entire records of the proceedings below are before your lordship. My lords are in judicial review. Whatever was there is there.
Supplementary copy দিয়েছো বাবু?
The parties are hunting me down, my lord. The parties are hunting me down. They are saying, please register the document. I cannot register document.
They are in possession, na?
They are in possession,
So
but they are
don't
sending me
accept.
notices, my lord. They will proceed against me. They are proceeding against me, in fact. My client came and he was in tears day before yesterday. That
No, what they are proceeding
they are
against?
proceeding against me because I am not being able to transfer title in their favor. Because the buildings have come up.
Who is proceeding?
The purchasers, the third party right persons who have
Brought in possession.
who have been brought in possession by agreements for sale. Now under Hira and all, they want it to be done. They are proceeding before Hira. And my life is in danger. I'll be physically beaten up someday. Now, my lord,
orderটা কি ছিল দেখো?
if they can only come up one day, it's a question of an arithmetical calculation. On the given date of vesting, whether I had more lands or lesser lands than the ceiling. It's an arithmetical calculation. You will just have to look at it, say yes or no, and the matter ends there. If I lose, I lose. But like this, my lord, client will die. He's under terrible stress.
That is why we kept it in the supplementary.
Yes, it was there. If a lordship recalls on the...
This is an appeal of 2017 writ petition. So, Mr. Banerjee, you have argued well, but the thing is that risk of life and everything.
No, risk of life, my lord, I'm telling you, lordship, my lord, a promoter, as it is promoters, my lord, my lord, development is the only business in the state, and promoters are the worst villains. Now, my lord, today, I am being hunted down in 500 forums saying that I am not giving transfer. Now, how can I, this injunction, I can't show it as an intermittent event. I'm not being able to protect it.
What is this CAN 1 you have?
CAN 1 is one for modification of the order of status quo in order to permit me to register the conveyances. It was essentially, my lord, a request in veiled form for your lordship to take up the main matter. The second is an application for early hearing, my lord. If your lordship modifies the order, permits you to do that, lord, it will.
Why you are saying praying for alternatively a prayer for early hearing?
Yes, yes. So that is really the. No one can. I mean, my lord, being a lordship's officer, I cannot. Only one prayer, my lord. Kindly sending it to paper books. Everything is there in this state.
Mr. Banerjee, it becomes convenient. We will fix a return date. You file your paper books in.
Yes, yes.
Some retirement day in the supplementary list.
We are mentioning the date on which.
And only one prayer, my lord. If subject to what falls for your lordship, my lord, I will reserve them if a time can be fixed, my lord. My lord, I am in terrible stress. I would not have
come up in the list first, Mr. Banerjee. In connection with the records reveal that in connection with the present appeal, an application being CAN 1 of 2021 has been filed on behalf of the appellants, primarily praying for expeditious disposal
to ওই reporter exception?
Records are not in order and you are.
It is the report. That means you have served upon them. But where is the original report? It is the copy of the report.
Exception দিয়েছে?
Yes, yes.
Exception file করেছে বলছে সেটা হতো
Exception?
কোথায় exception file করেনি?
বলছে তো।
It's okay.
Have you used Excel? Check it up then, Mr. Banerjee.
I'm checking up on it. আমাদের কাছে এই একটা যে রিপোর্টটা তার কোনো এক্সেপশন শিওর
We are, don't prepare your paper book now. You get your records. We are fixing a date. You get your records in order.
My lord, only one prayer. I am now instructed that we didn't file any exception to that BLRO report. We were told to file a separate report on our own on our holdings and total land held by us. That report, upon service to them, we have
Then you file the paper book, incorporate
everything. I will incorporate all papers that are before me. This I am filing, my lord, the affidavit of the petitioners. File kar dito. In terms of the order dated.
Oh, you are directed to disclose the particulars of the land you are holding.
Yes, that I have given. Let this remain, my lord, everything will come. Everything will come in the paper.
You incorporate that in your paper.
Everything.
So we application gulo kete dao. Hard learned advocates appearing for the respective parties. The appellants are directed to file informal paper books incorporating all documents and pleadings exchanged by the parties before the learned tribunal and also before this court earlier. Within a period of 2 weeks from date, with a copy to the learned advocate on record of the state respondents. Lease the matter for final hearing in the daily supplementary list of this court under the same heading on 13th February. এইসব কমেন্ট কোর্ট চলাকালীন করবে কি
My lordship, may kindly recollect, my lord, on the last occasion, your lordship asked me to file a supplementary affidavit enclosing the writ application. My lord, I am the respondent appellant in this case. Respondent in the writ application and appellant in this case. But this is that case, my lord, where certain plots of land belonging to the petitioner, my lord, we are in occupation of 2 shops in front of that land, plot of land. My lord, they filed a writ application for alleging encroachment and removal of that.
Same order in the morning.
No, my lord, and the order under notice under section 10 of the Highways Act was passed, 10(1) of the Act, which is that order. Well, asking us, my lord, to remove the encroachment within 15 days. Now, my lord, your lordship pointed out, my lord, I have also gone through the section 10, 1, 2, 3, and 4. But the procedure, my lord, I have seen. My lord, I am only praying, my lord, that till that procedure is exhausted, my lord, I may be protected. I may not be removed. Because I will participate in that procedure. I have to participate, my lord. Because
No,
15 days.
how can they remove you after their time period for preferring appeal against 10(4) is also
Yes,
provided.
my lord, I have seen. It
So
is there,
we
my lord.
cannot-
Appeal can be filed before the DM.
Can
District
we
magistrate.
improve upon the statute? And your apprehension is not proper because they will have to go through these stages.
The only thing is that, my lord, writ petition has been filed, my lord, by the private respondent herein, not by the PWD. On whose land, my lord, alleged encroachment is there. So, my lord,
How does that, because the.
He is claiming that he acts useless and.
yes,
Yes,
yes, yes, that is their claim, and for that they filed the writ application.
Now, order disposed of asking BLRO to hold an inspection and to submit a
Yes,
report.
that
Has
was
that
done.
been done?
Yes, that was done.
That was done, you were present.
Yes.
Acha, then it has now been sent to the assistant engineer PWD.
On that basis, the assistant engineer PWD has issued a notice under 10.1.
They have passed an order one. You have participated before him also. Then what remains? We asked you that you withdraw the appeal.
But it happened much after, my lord, this appeal was filed. But the appeal was filed.
Now.
Yes. Now, my lord.
3 and 10-4.
But 10 to 10-3, 10-4, yes.
10 to 10-3, 10-4.
Yes, my lord.
So, yeah,
The lordship can dispose of this application, my lord. In view of the subsequent development,
participated.
in view of the subsequent development, my lord, which has taken place during the pendency of this appeal, lordship can dispose of this appeal.
Now, now it is in which stage? Assistant
10-1.
engineer has also passed the.
Yes. My lord, only section 10-1 notice has been issued to them
10-1
in order to
notice.
show that directing them to remove the structure by their own.
10-1
Thereafter, my lord, we shall issue the notice under section.
10-1 notice was issued on 2nd of January. It is for 15 days, that is 17th.
15 days time has been given.
17th, my lord, Friday was the date.
We can
This matter was taken up by your lordship on Thursday. Directing me to my lord to file the writ application in the form of a supplement. Oh, hey. And we have served copies also, my lord.
What is that?
Well, the writ application was not annexed in the appeal, my lord. Lordship granted me leave to file it. The affidavit of service.
Order 10.
10 to 10 to যদি না সরায়।
My lord, your lordship kindly come to a report, my lord. Apart from the appellant, my lord, also the petitioner, read petitioner, he has been also served the notice. He is also encroacher. My lordship kindly come to a report, my lord. He has also been served the notice, section 10-1.
We are not interfering.
Yes, madam. Yes.
The order dated
Mine. 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 Grateful.
Delegate করেছে to take steps. এই করে লিখবে। Today, 3 p.m. Mr. Cord, we are having another original side matter. My brother won't be available for next week onwards. Yes, the circuit bench.
Let's come back on.
Lord, I can only say this. I don't know how long my learned friend is going to take.
You said that you will take half an hour. And
Maximum less than half an hour.
so can we say that we can, due to this reason, if we finally hear, we should deliver the judgment immediately. But neither my brother would be there. The regular bench would not be there. So, subject to what you people say, we can make it as harding part and keep it on a particular date and time.
Lord, subject to my lord's convenience, kindly do whatever your lordship feels, Lord, whatever, because we are.
No, we must tell this to you because you would be.
My lords have substantially heard the matter.
Yes, we have heard it. We will hear your reply.
Kindly make it returnable after my lord comes back from the circuit.
Yes, it can be because succeeding after my brother goes, it would be my turn. So we would be reassembling in the last week of February.
Lord, whichever.
কত এই ফেব্রুয়ারি আমি কবে ফিরছি বলো না 20 তারিখ
But in fact, I was suggesting if my learned friend Lord completes his submission, then Lord at least
that we can hear, no problem with that. So that we can hear.
Yes,
I'll tell you, Lordship. I am in a bit of a difficulty, not right now, but will be in a bit of difficulty. Third 2 p.m. matter in another court also. My lord, second one is going on. I cannot
say. Mr. Banerjee, you can conclude within half an hour.
What I can do is this. I said that I will be sharing my judgments with Mr. Kaur. That sharing of the part has not been done because of my fault. It is my fault. My advocates on record are not to be blamed for this. What I can do is I can share my argument and the notes with him so that he can come back ready. That is because otherwise, my lordship.
But I have no.
On the same day, my lord hears both of us. It will be easier for my lord to deliver judgment.
My learned friend has already substantially argued his matter.
My judgments are still left.
Yes.
Instead of concluding today, completing today.
শুভ্র কবে বলছে তো?
ওরা তো ফাইল করলো আপিলটা হিয়ারিং করলো সময় নেই সে কি করবে ইয়ে থেকে আমি রোজ সুবিধা আমার যেদিন বলবে শেয়ার দরকার
PM থাকবে ওটা আমরা তারপরে আচ্ছা
Or at least, Lord, we could have made some progress if my learned friend, Lord,
They assist, I think that may not assist.
that would.
That day, your lordships here, whatever I had to say in my submission, so can close it out and then my lord can deliver orders.
22nd
বলে ভালো হয়। আজকে আবার বললাম, আবার 4 সপ্তাহ বাদে কিছুটা তো মাইন্ড থেকে অফ হয়ে যাবে। আবার সেই এক কথা।
But if you conclude, then obviously.
Was supposed to file a supplementary memo of appeal. He has not filed that also.
এই পয়েন্ট তুই নিয়ে না। পয়েন্ট
দেবে না আমাদের?
না, দিচ্ছে না।
24 তো ফিরে আসছে। Heard the learned advocates appearing for the respective parties. List the matter for further consideration in the daily supplementary list of this court on 25th February as fixed at 1 p.m. We have 2 p.m. fixed matter, but we will continue with yours. Otherwise,
okay.
Otherwise, from 25th to
It would-
3rd of March, we have 2 p.m.
It would be inhuman, Lord, to ask your lordship to continue because again the 2 p.m. fixed matter will
We
be.
will hear
No,
you,
no,
Mr.
it will continue and hence it is fixed at 1.
ও মানে আগে ওইটা হয় তারপরে 2 PM টা আসবে।
We will hear you and then take up. If you have any, you are having any difficulty on 25th, Mr.
No. I am thinking about the court.
The matter shall be treated as hardship.
রিসোর্স হবে, টিফিন হবে।
They are not here. I think they are not here in the circuit.
একটার সময় করে এরকম দেখলে
Receiving end. At the receiving end. Our property, we can't do anything and they are merely not pushing the matter back. Very sorry.
I am for the
they
respondent.
have not pushed the matter back.
I'm talking about them.
To have objections to that effect, we can hear it today.
Your lordship kindly, in that event because the understanding was on the previous.
So that you talk with Mr. Cord. That,
As your lordship.
yes.
25 is my appeal. But this is the case of
Supplementary আছে। Supplementary affidavit file.
supplementary paper book. I am the appellant, I file a paper book. They say that some papers were missing, they took the initiative in filing the supplementary paper book. Well, this is the case of a resumption of the property Salt Lake. Well, I will kindly comes to the order impugned, madam. The lot was allotted in 1983. No construction was made as per the rule.
Which page?
Page 38. Page 38 is a copy, certified copy, will kindly comes to page 54. Page 54 of the paper book. আছে তোর কাছে আছে তো?
54.
Page 50.
Yes.
The subject matter of challenge in this writ petition is a resumption order being.
We heard it earlier, no?
That is another one. That is modern design. All more or less same matters. That is modern design.
That is also on that issue, no?
That is coming up on 22nd. Before your lordship, for final hearing. That is state versus modern design. This is state versus Shamostina. 3-4 matters of more or less same.
What are the other matters?
Other matters, lordship has passed a judgment, but I'll rely upon that while doing these matters.
sitting with Justice Raja Basu Chaudhary in Court 32.
That is not similar.
That is similar with modern partnership and all the issue which arose on that day. This is simplicity resumption. 83 leased out, nothing done, we resume. Well, kindly come. The subject matter of challenge in this writ petition is the resumption order being number 2087 dated November 2, 2018, issued by the respondent number 4, the land manager, Bidhannagar, Government of West Bengal, Urban Development Department, as well as the show cause notice bearing dated 2017 issued by the same respondent. The affidavit in opposition filed on behalf of the respondents and the affidavit in reply filed by the petitioners are taken on record. By the impugned resumption order dated November 2, 2018, the respondent number 4 cancelled the offer of allotment order bearing number dated 27th of April 1983 and the lease deed dated May 3, 1983. By the said allotment order and the lease deed dated May 3, 1983, the state of West Bengal had granted a lease in respect of plot number 264, block FD, sector 3, Salt Lake, Kolkata 106 in favor of the petitioner's father since deceased. Petitioner's fathers were the original lessee. Then, the principal ground urged by the petitioners to challenge the impugned resumption order dated November 2, 2018 is that the same is not in conformity with the clause 4 of the lease deed dated May 3, 1983, read with the proviso thereto. As per the proviso to the clause 4 of the said lease deed, any exercise of right of re-entry to the leased plot of land shall be preceded by the issuance of a 6 months notice prior to remedy the breach. Accordingly to the petitioners, in the present case, admittedly there is an absence of 6 months prior notice to terminate the leasehold interest in respect of the said plot of land. Mr. Banerjee, learned senior advocate representing the respondents as well as the respondent 4, in his usual fairness, submitted that after going through the records of the case, he found that the impugned resumption order was not preceded by issuance of 6 months prior notice as mandatorily stipulated by the proviso to clause 4 of the said lease deed dated May 3, 1983. In view of the above, when the impugned resumption order is not preceded by 6 months prior notice, allowing the petitioners to remedy the breach of the lease deed dated May 3, 1983, WPA 5439 of 2019 stand allowed. Accordingly, the resumption order dated November 2 being annexed P15 to the writ petition stands quashed. As a necessary corollary, the impugned show cause notice dated discussed. And this is the order impugned. Here, what will kindly comes to the affidavit in opposition filed on behalf of the respondents, that is at page 29. The order is very clear. There has been an admission that since there has been no notice under clause 4, this is the affidavit in opposition which was filed before the trial judge.
That is page
29 of the paper. This paper book from where I read the impugned order.
Yes.
Well, affidavit in opposition. This is I, Muhammad Asif Iqbal Malak. I am the land manager.
Where is that paragraph? That is the only ground. No? Where do you have stated that?
Well, it will kindly comes to page 30, paragraph 4.
You want to show anything else? Page 30.
Page 29, my affidavit in opposition starts. 29. At page 30, paragraph 4. These are the points which we have dealt in the affidavit in opposition. Well, kindly goes through these 4-5 points and decides the issue. Well, before dealing with the allegations contained in the petition, I state the following facts which are pertinent and relevant for the full and final adjudication. Well, these are certain dates with the facts. On 3rd of May 1983, a plot of land being premises number 264 in block FD in Salt Lake was transferred by way of a registered lease deed dated 3rd May 1983 by the government of West Bengal in favor of one Mr. Kalicharan Saha on the terms. The said lease deed specifically mentioned inter alia that the said Kalicharan Saha would construct a building at the premises within 3 years from the date of possession of the same. A possession certificate in respect of the premises was issued on 2nd of September 1983. Para 4. D.
The said Kalicharan Shah died on 18th of April 1988, having failed to construct any building at the premises despite having had ample time and opportunity to do so. The clause states that you have to construct a building within 3 years from the date of taking possession. Such omission on the part of the said Kalicharan Shah was clearly in violation of the terms and conditions of the lease deed. From 1988 till 1997, the premises was, well, this is 1988 means from the date of death of Kalicharan Shah. 83 was allotted, 88 Mr. Shah expired. From 88 till 1997, the premises was left vacant and no construction was made thereon. These two was clearly in violation of the terms of the lease deed dated 3rd of May 1983. Wide memo dated 1406 dated 97, mutation was accorded in favor of the 8 legal heirs of the said Kalicharan Shah upon the same terms and conditions contained in the lease deed dated 3rd of May. But even thereafter, the legal heirs failed and neglected to construct a residential building at the premises, which was again clearly in violation of clause 26A of the lease deed. Thereafter,
6A is the same clause.
Same clause, 3. We have to construct within 3 years from the date. Thereafter, 6 mutated co-lessees gifted their shares in premises to the petitioners, and subsequently a further mutation order was made on 1998, same, subject to the compliance of the lease deed dated 3rd of May. Even thereafter, and despite having been given ample opportunity, the petitioners failed and neglected to construct a residential building.
But Mr. Das, why did you enter into fresh lease with the persons who were there?
It was for the father.
It was with the father.
Father expired.
But you could have taken that point thereafter. Instead, you mutated their names.
83 it was given.
Twice.
83 it was given. 88 father expired. From 88 to 97
it was vacant.
8 legal heirs they came. We got that mutated.
That Mr. Das, once you mutate it in their name.
Mutated is they will kindly
please show us.
2-3 more times.
So there was
nothing much in this matter.
No, we are just interacting.
Yes.
We
should not have done that.
Very good. So that the last mutation was in 98.
Then, even thereafter, and despite having been given ample opportunity, the petitioners failed and neglected to construct a residential building at the premises, and ultimately by a show cause in 2000, under clause 26A of the lease deed was issued by the respondent authority, and the same was returned undelivered. But no building, nothing there. Well, it has to come undelivered. The said show cause notice was resent on 14th of February 2001 for compliance, but the petitioners failed, neglected, and refused to respond the same. Well, around 2016, the respondent authority received a prayer.
That is 15 years thereafter.
Yes. We received.
Because was in 14th of February 2001.
And this is in 16. After 15 years, we get a representation from them. On 2016, the respondent authority.
So when was the second mutation done?
1988, 98.
98.
83, 88, 98.
Yes, then 20th
2001,
October
then
2006 received a prayer from Premanshu.
One Premanshu Sarkar inter alia for permission.
Present lessee.
No. There are others. Now it is with the sinners. Well, I'll come back. On 20, the respondent authority received a prayer submitted by one Premanshu Sarkar inter alia for permission to transfer the premises in the name of Premanshu Sarkar on the basis of a memorandum of agreement of sale dated 1986 made between the original lessee Kalicharan Shah and Premanshu. Well, this gentleman in 2016, he comes with a prayer to get it transferred in his name on the basis of a memorandum of agreement of sale 30 years back. 1986, he says that the original lessee who has died in 88, after 30 years he comes and says that I had an agreement with the original lessee. And
yes,
now,
then what happened?
Now you transfer in my name. Well, it is pertinent to mention that such sale agreement was clearly in violation of clause 2.8 of the lease deed dated 3rd of May, which states that the lessee shall not assign or transfer or such and such, such and such. This was again a second violation, 2.6a, this is 2.8. Then it became apparent that the original lessee had no intention of constructing a residential building at the premises and instead wished to sell the same for unlawful gain. In the circumstances, the concerned department conducted a survey of the premises and submitted a report on 2017 stating that the premises were still lying vacant. In such circumstances, the respondent number 4, while a memo dated 2106 dated 20th of January 2017 was constrained to call upon the petitioners to show cause within a period of 30 days as to why the premises should not be resumed by the government. Upon failing to receive any satisfactory reply to the show cause notice from the petitioners, the concerned department was constrained to cancel the allotment of the petitioners while dated on 2018 and possession was taken on December 2018. Well, these are the facts. He challenges this writ petition.
But who is Sina? How Sina come into the mix?
Sina
is the original.
Writ petitioner?
Writ petitioners.
No.
Son of the original allottee.
Son of the original allottee. But he
Two
says
sons.
Sons of eight legal heirs. 6 of them got their name mutated. 6 of them transferred to them. And this Premamshu Sarkar is not the legal heir of that original allottee. He says that in 1986, I entered a memorandum of sale with this Sina's father stating that he has sold me the land. This is the case. But these are absolutely facts. There's the writ petition, my lord. Then the writ petition, my lord. The order was that. And now may I take the copy of the writ petition? Paper book. There's nothing more than this in this matter. My lord. Kindly comes to the supplementary affidavit. The writ petition is there.
বলছে যে কালচারাল সিংহ করেছে
না
না have you not annexed the lease deed?
Yes, in the writ petition is there. But I read from the affidavit in opposition. Writ petition, my lord, kindly takes the supplementary paper book prepared by Subhashish Saha.
Yes.
Well, kindly comes from para 2. Page 29 is the copy of the lease deed. Well, these are more or less same. Page 29 of the supplementary paper book. But I has got it?
Yes. Yes.
Within 3 years.
Malad, kindly come. 26A is 3 years. Up clear. Well, dealt with many matters. Malad, kindly comes to page 29. This
wanted to show page first.
29 is the lease deed of the supplementary paper book prepared by Mr. Saha.
Now, where 6 month prior notice provision for giving
4.
6 month prior?
4. Surplus 4.
35.
Para 4 of
page 35. Internal page 7 of the lease deed. Para 4. Pencil আছে.
This is with Kalicharan Rai.
Well, Kalicharan
Kalicharan Sina.
This is the lease deed. Well, I'll go to paragraph 26A once first. Page 31. Running page 31. Internal page 3 of the lease deed.
Yes.
Well, kindly comes A. To construct the building in conformity with such building rules.
6A.
6A. 26A. To construct the building in conformity with such building rules as may from time to time be framed by the government or other authority prescribed in that behalf and according to plans, specifications, elevations, designs and sections sanctioned by the government or that authority within 3 years from the date of possession of the demised land, that is from 83 to 86. The gentleman dies in 88 and the other person who comes with a letter in 2016 says that it was sold
He expired in 83.
88. Possession took on 83.
Yes,
then it's 26. Then my lord comes to 28.
Yes.
Another violation. The lessee shall not assign or transfer the demised land or any part of the demised land or the structure erected thereon within the without the previous permission of the government in writing. In case the transfer or assignment of the lease, the lessor shall have the right of preemption and upon the exercise of this right, the building constructed by the lessee on the land shall be taken over by the lessor at a valuation of the building made by the lessor on the basis of the cost of the construction of the building. This is violation. This original allotee could not have sold. It's a violation of 2(8). And then I will kindly comes to page 35. Running page 35, internal page 7, paragraph 4. This is what they had in the writ petition. Provided always that if there be any breach of any of the terms and conditions and covenants herein on the part of the lessee, contained, the lessor shall have the right to re-enter into the possession of the demised land or any part thereof in the name of the whole land thereupon shall forthwith stand determined, provided nevertheless the lessee shall not exercise the right without serving the lessee by writing giving a 6 months notice. He says that this 6 months notice was not done. There are other violations, 26A, 28. Simple, but that is all.
Maybe, but you have given 6 month notice. Whereupon you will show the same.
Well, admittedly, 6 months notice was not given. That is in the order. In the writ court order is there. Nothing can be enforced.
So that this order, this has to go show cause notice. That does not stop you from taking appropriate steps in future.
We were on the 2 violations. And I will kindly comes to the order impugned.
No, সেইটাই।
Now it kindly comes to page 69 once.
Just.
Page 69.
চলনের অনেকগুলো দেওয়া হচ্ছে, অনেকগুলো 8 লিগালি আসছে। আমাকে 2 লিগালি আসছে মানে
But out of the 8, 6 have transferred them to the other 2, the 2 brothers.
Mutated code is gifted their share to the a further mutation was ordered. আটটার মধ্যে 2 জন।
আর দুজনের কি
আর ওরা চলে গেল, ওরা বললো যে আমরা নেবো
সেটা। ওটা
ওদের পোর্শনটা গিফট করে দিয়েছে শেয়ার।
69 is the order under appeal.
Other 2 years
order
করেছে Wedwi.
সেটা আনিনি রেকর্ডে।
So mutation was in favor of the 8 legal heirs. That was in 97.
Then 6 of them gifted it to their 2 brothers who are the writ petitioners.
6 of them gifted it to these 2 brothers.
2 brothers.
So next this
now they were the writ petitioners.
No, see, gifted their shares. Now there was a second mutation, no?
First mutation was from under the death of the father.
Kalicharan to his Sinha's son.
Kalicharan Sinha to his 8 legal heirs.
That's very good.
Daughters, sisters, daughters, sons, whatever it is.
Now those 8 legal heirs was mutated.
Then
thereafter
6 out of them had given to these writ petitioners the respondent. And
so they have entered into agreement with the
not they
in interest of the mutatees.
Not they. He says that the father had done.
Father has executed
in 86. He died in 88.
In
favor of one Premanshu Sarkar.
Premanshu is not before us.
No, he is not before us. He applied to us.
That you have rejected.
Deal with accordingly.
Well, it kindly comes to page 69.
Now, how you have not complied with the provision of proviso of 4.
Well,
so how you can overcome this?
Well, I told at the very beginning, Malad, this is what, and it has been submitted by the learned advocate appearing on behalf of the state before the trial.
6 month notice.
Yes, stated that.
Admittedly, issued a so-called notice in 2017 and call him to explain. However, whatever be that.
Where is that show cause notice?
My lord, kindly comes to page 69. This is the cancellation of allotment.
69 of you have given two papers.
My lord, supplementary paper book.
Huh?
Supplementary, from where the writ petition is annexed. This is a part of the writ petition. It's annexed there, page 69. Two, Shamol Sinha, Subroto Sinha, cancellation of allotment for violation of clause 26A of the lease deed in respect of the plot of land leased out to Kalicharan Sinha. This is in 2018. Whereas by a deed of indenture executed between the governor of the state of West Bengal and original lessee on 3583, a plot of land being 264 block FD Bidhannagar was leased out to Kalicharan Sinha on the terms and conditions as set forth in the said lease deed to erect a house and building thereon within 3 years from the within 3 years from the delivery of the possession of the said plot. And whereas the delivery of the possession of the aforesaid plot was on 2nd September 83, and whereas in terms of clause 26A of the aforesaid indenture, the lessee is under obligation to construction the building within 3 years from the date of possession.
Just wait.
Focus notice.
Easy কোথায়? Focus notice to 6 months.
Para 4 of the lease deed. Malawi kindly comes to running page 35.
Yes.
Running page 35. This is the
Page 35.
running page 35, internal page 7, para 4, 6 months notice.
Yes, no, you were placing that.
I was placing page 69. 3 years. Then, and whereas the governor of the state of West Bengal was pleased to serve you a notice under clause 26A of the lease deed for explanation within 90 days from the date of issue of this notice by department memo dated such and such as the clause was
What
filed
is
vacant.
from the date of issue of this notice? That is to 2nd November 2018.
Yes. Then, and whereas it reveals from inquiry that on 11th of January that the plot is still lying vacant till 2017. That is more or less 34 years gone. Then, and whereas the governor of the state of West Bengal was pleased to serve you a notice under 26A, lease deed explanation with 30 days, why the memo dated as the plot was at. Now, therefore, I am on no answer. Now, therefore, I am on behalf of governor of state of West Bengal directed to say that the governor of the state of West Bengal has been pleased to resume the demised plots such and such, or by cancelling the order of allotment dated 83 and the lease deed dated May 1983 under clause 4 of the lease deed. Then you are requested to hand over peaceful physical possession of the plot of land along with plot related documents in original within 15 days from the date of issuance of the
Now,
letter.
please read that paragraph once more.
Which one
Whereas
that
the
is?
governor of state was pleased to serve you a notice.
Under clause
This you are
26A.
referring to two brothers.
Huh.
Under 26A of the lease deed.
So
For
that is
explanation
why
within
you
30 days.
to explain within 30 days and 26.
Where is that notice?
The notice is at page 59. Page 59, Malak. 20th of January 2017.
Just.
Shamol and Subroto. Malak has got it, page 59. show cause notice for violation of clause 26A of the lease deed dated such and such. Whereas
So after 20th January,
20th January 2017, we give them.
now does he give a reply to this?
Kindly see. From the next page is the reply, my lord. Kindly
That is on 8th of February within a month.
2017.
That is within 30 days. Now he gives a reply. And in consideration of the same, you pass the 2nd November 2018.
Now then again on 19th April 2018 we have given. Immediately the next page, page 61. He asked, we had put a notice board. He has written to us, kindly remove the notice board. It's a vacant plot.
So this was a 19th of April 2018.
On the 19th of April 2018 was my letter. At page 61.
30 দিনের যেটা দিতে হবে 6 months notice. 6 months notice, তাহলে এই অর্ডারটাকে চ্যালেঞ্জ করবো না ওই সুকষ্টকে চ্যালেঞ্জ করবো। রিট পিটিশনের সাবজেক্ট ম্যাটারটা কি?
Well, kindly comes to the prayer of the writ petition, madam.
Second November 2008. দুটোই চ্যালেঞ্জ করছে। তাহলে কোনটা 6 months নোটিস হবে? 20th January 2016 টাই 6 months রিপোর্ট হবে। হ্যাঁ notice. You are very much video. This is even এইখান থেকে না বললো এই নোটিশটা ব্যাড। The resumption process. এই নোটিশটা ব্যাড because this is not 30 days notice, no, it should be 6 months notice. এই পয়েন্টে উঠিয়েছে এবং সেটার বেসিসে স্টার্ট করেছে তারা। সেটা হচ্ছে রেসপন্স টু ইজ রিপ্রেজেন্ট প্রেজেন্টেশন পোস্টারের সিক্স মান্থসের নোটিশটা আমরা ইন্টারপ্রেট করতে পারবো না। যেতে পারি কি প্রেজুডিস আর যদি এরোনিয়াস নোটিশ সেইটা Then what happened after 19th April?
Well, then kindly comes to
page 61, 19th April we saw. Then he made another prayer.
Who?
Sinha. Page 62.
Page 59 was that show cause notice. Page 60, request for removal of your board. 61, we answer. Again, 62, he writes. Same.
62?
Same request for removal of notice board.
That is on 24th May.
24th May.
Then what happens?
Well,
again, 31st May, he writes.
Same.
This is pertaining to removal of the board from.
Well, we have put up notice board there.
So then what happens?
Then again.
Resumption notice.
Well, page 67, my lord will kindly comes. This is what was sent, and 69 is our resumption.
Permission for removal of the board.
Straight away, page 69, cancellation of allotment for violation of
23. Then what is page 24? 64?
64 is.
This is a type copy.
31st May 2018 letter was early. That is a type copy. And we were basically on 2 counts.
কালকে নোটিশটা কি সমস্যা কি সমাজ পিরিয়ডটা তো এর মধ্যে মামলা করতে করতে চলে যাচ্ছে।
From your end?
Now the show cause notice which was page 69. This was the cancellation of allotment.
Yes, cancellation of allotment for violation of 26A.
26A, that is
3 months.
3 months.
3 years. 3 years. 3 years এর মধ্যে করবেন. We have to do it by 3 years. 28 we did not say anything. They did not say, we did not say. The first time it surfaced was in our affidavit in opposition that there is some other third party who says that yeah, I have purchased the plot and I would. So 2 violation, 26A, 28.
No, that is not, that is neither of,
but
that you have not referred to in either page 69 nor in your initial show cause.
Well, this is 2018. This was subsequently. Well, what happens? This was not a part of the writ petition. They did not come with that. We took it in our affidavit in opposition.
2nd November 2018.
No, that
memorandum of agreement.
Yes, that we took out in our affidavit in opposition.
Yes, that you have stated.
Yes, I've stated.
Did you annex the?
No, we did not have that copy. We did not. Kindly.
How does that improve your case?
Does not, but well, I don't know what they have written in the reply in regard to our that.
Which?
Well, kindly comes to my
reply to what is, where is the affidavit in reply?
Well, coming. I'm coming. কোথায় রে তোর এফিডেভিটের রিপ্লাইটা রে?
অ্যানেক্স করলাম না ইয়েতে সাপ্লিমেন্টারি সঙ্গে
দিচ্ছি রে দিচ্ছি। Well, this is when in my affidavit in opposition, I took it in paragraph 4, subparagraph I. And what is his reply to my paragraph? Kindly comes to their affidavit in reply.
In the supplementary paper book, it starts from page 71.
71.
Achha. Page 71.
Yes.
EF. And I'm coming, my lord. Kindly come.
75.
70.
Yes. Paragraph number 10.
Page 75, paragraph 10. The petitioners deny and dispute the statements made in paragraph 4I of the affidavit in opposition under reply. The petitioners deny and dispute that the memorandum of agreement for sale dated 86 made between the same original lessee Kalicharan Saha and the said Premangshu Sarkar. The petitioners do not know who the said Premangshu Sarkar is and is unaware of the existence of any memorandum of agreement dated such and such.
They have denied.
They have denied.
You should have filed a supplementary affidavit to bring that clear.
You should have made that application before the rate court. That this is the story you bring in on record.
Whatever the state advocate has done, my lord, it's there. I cannot
Yes,
improve
Mr.
that.
Lairi. What prejudice you have suffered?
But
Single
first,
notice is a technicality. Has it interfered with any protection of yours?
my lord, first, my lord, may I submit, my lord? It is the case of the writ petitioner that after the writ petitioner's names were mutated, we have been writing to the respondent as well as the municipality. We have got a plan sanctioned. We have been writing to the municipality that to the respondent state that we want to construct.
Where is that?
To the part of the record, my lord. In 2003, we have written.
It was mutated in 1998.
19, my lord, mutated in.
First mutation 88.
Till 2018, you could not get all the necessary formalities completed.
1998,
1998, it was mutated in your name.
my lord. Thereafter, we have been writing.
Thereafter, for so many years.
Well, we have been writing letters.
Yeah.
Well, we have been writing letters. We were, my lord, working somewhere else due to our vocation. We were out of Calcutta. When we came back, we started to try to make the building. Well, I cannot improve. Well, 2000, there are letters, my lord, annexed to the petition, writ petition.
That all those are emerging about 10 years after you have purchased.
My lord.
15.
After mutated.
After muted.
2002, there's a letter, my lord.
20 years.
2002, 2003, we have written letters.
Where you are?
But P6, page 51 of the writ petition, my lord. Our paper book, my lord. Page 51.
Page 51.
My lord. Nothing answered.
Page 51 in your supplementary.
Supplementary paper book, annexed to the writ petition.
Page 51. Yes. Page
Request for extension of time to construct is the.
That is on 13th of September
2002. Then again, the next letter is 2003. No reply. There is no reply from them. Finally comes to page 56.
গভর্নমেন্টের 6 মাসের যেটা সেটা গভর্নমেন্টের চেতনা হলো না যে আমি নোটিশ ক্লেরিক্যাল 6 মাসের নোটিশ দেওয়া উচিত ছিল হয়ে যেত সেটা হচ্ছে within his knowledge at this point will that attribute the goods for shall be deemed to be compliant সেটা থেকে তুমি settle principle even cannot incorporating an explanation to transaction.
Page 56, we get a plan.
That they have nothing to do.
But we get a plan from municipality. Now we write to them in 2006. Next page.
Plan
Again,
was
extension of time.
Plan was of
2003.
Plan 2003. Very good.
Then 2006, we write to them, extend our time. Next page, 57.
This what is the date of this letter?
Date of letter is next page, 19/8/2006.
19/8/2006. That
Yes.
is 3 years after the plan.
Yes.
By
There,
that time it has
there
lapsed.
maybe the 5 years the plan is alive. A plan is alive for 5 years. But there are letters, but no reply, because unless they give us the urban development give us a letter, I cannot start.
Proposition, sir, your cause of action will not stand extended for their inaction. By that can be made up by repeated representation. You ought to have challenged their action that why you are not considering. You consider and reject my case, or you allow my case. This was way back in 2003.
2006, my last letter I have annexed. But my lord, thereafter, my lord, whatever action they have taken is beyond the lease deed.
Let us read clause 8. 6 months notice.
6 months
What
notice.
is notice? Notice is something you have to be made aware of. You were made aware of you yourself, you are admitting I have not been able to make the building. See, my sanction plan is of 2006. So it can be accepted that till 2006, you within 3 years, you never by any formality you have
But
done.
my lord kindly takes envisage a situation. Take a notice under 6(4) of the West Bengal Premises Tenancy Act. It has to be within 1 month. That notice is notice. If it's beyond the period of notice, notice is bad.
But it is
But
statute.
this is interpretation of the agreement.
That apart, when you made application on 19th April, they stated resumption process has started.
But they have
Clarify whether that notice would not be treated as a notice under section provides of clause 4.
Why not kindly sees the show cause?
That means the resumption process, they are going to resume the process. Land.
No, they have already.
Brought to your knowledge.
No, they have. My lord, kindly sees the show cause. After the show cause, they put a board. After the show cause is again 30 days, not 6 months. The first show cause, which is at page 59.
Now today, if we are with your contention, if we dismiss the appeal,
my lord,
then what happens? Now they have to give you a 6 months notice again. By that time, you will construct.
By the time you will keep some building big.
No, I have to take permission. If they do not give me permission, I cannot construct. I will not get a sanction. And there are letters galore to them.
Was that clause of the lease deed that unless it is, it has to be a sanction building plan.
Yes.
Is there any reference to such a plan in your lease deed? That sanction cannot be granted without the prior permission of the state. Any action.
Yes. Sanctioning authority is Vidhannagar municipality. They will require no objection from Urban Development Department.
Where is that in the lease deed?
Where is the state? Where is it? Sanction without.
No. Yeah, 6A. 6A to construct a building in conformity at page 31.
Whose building rules? Oh, this will be by this.
Yes, unless they give a no objection, Vidhannagar Municipal Corporation will not allow me to construct.
Where you have taken this point in the writ petition? So as that I have not been able to construct the house for 22 years since my permission was withheld by the authority concerned.
Well, every page, I'll show from the writ petition.
For 22 years it was withheld by them. 30 years.
Ajay, you search your.
I've searched. I will kindly take page 12.
We have an original side 2 minutes matter. We will take up this afternoon. Very good. Take the original side. Look, just wait for.
All right, I'm waiting.
Under compelling circumstances, I'm mentioning this matter, Lordship, at this hour, Lordship. This is an assigned matter by the Honorable.
Mention when we next sit with the original side. Today, just we have to finish it off. You mention to us when we next sit in the original side.
Side,
এই 12ই ডিসেম্বরের অর্ডারটা আছে আচ্ছা lordships would be pleased to come to the second page of the order dated 12th December 2024 আর একটা কপি দিন না একটা কপি আছে বোধহয় The second page, my lord, the last paragraph of the order of 12th December. In this said,
Come us with no application has been filed.
Sorry, my lord.
Have you filed any application?
No.
Then how will we do, Mr.
It is done, my lord. That is normally done. Extension of time to file the affidavit, my lord, is normally done.
We are no longer with that appeal, na?
Still, your lordships have given a time, it can be extended by your lordships, my lord.
The joint prayer.
No, if they consent.
Kindly don't record my consent. I'll tell you why. Lord, Lordship will extend. I'm not standing in the way, but kindly don't record my consent.
That is for different reason I can understand, but
no, whatever the reason, I have not, my lord, because I'm not.
To this too.
So, my lord,
but I can tell you,
but
lordships, my lord,
Lordships can pass that order. I agree with
lordships
Mr.
can,
Mitra.
yes. That is normally done, my
Yes, I'm not standing in the way, but kindly record, my lord, that I have objected and not on consent, my lord.
It is done.
It is done. It is done. Otherwise, I would not have come up before your lordships at this.
So if they challenge our order now, they will take all those grounds. Court functus officio.
Very well. We shall deal with that. We shall deal with that.
My lord, I don't think, my lord, this order, my lord,
Don't make us feel
we are going to
No, no.
challenge, my lord. But the other appeal, lordships put a query to me on the other day, my lord, from the other appeal where your lordships had passed that order in the order 7 rule, that, my lord, perhaps an appeal has now been preferred. Just to bring to your lordship.
Oh, I see. No, that's neither here nor
No,
there.
lordships had put a query to me, my lord, so.
Service করেছে? We are on caveat, but it has not been served. Senior কোথায়?
You don't even know where your senior is.
আর যদি ওকে লিখে লিখতে না তাহলে সেটা কোর্ট বলবে কোর্ট করে It is better had you been allowed to write down consent. Actually, we are
Everything would have
become
been-
functions
Well,
of this.
Well, how much time you require?
Fortnight's time I was playing, but
Unfortunately, my lord, I am a creature of instruction, so my lord, my instruction is not to give consent.
So you leave it to our discretion. We will record that.
No, that. But kindly don't, my lord, in your discretion, my lord, record that I'm
has to
giving
be.
consent.
Even if he, my lord, opposes, even if opposes,
No, that will go
Actually,
as.
we are thinking about we are functions of issue. Now disposed of, we have already recorded. The appeal is disposed of. Now we are touching again that appeal and passing a further order. And we are thinking. And you are not allowing us to
Consent. Lordships have the power, my lord, to, my lord, make that.
not seriously opposed to.
My lord, kindly don't, my lord, kindly don't write that, my lord. I'll be in difficulty, my lord.
Records reveal 6th February.
Lordship, I'm grateful.
Yes.
আরে ওরা থাকবে না দেয়
তোমার তো হয়ে গেছে সেটেল করা তোমায় বলেছো
একবারও বলিনি। একবারও বলিনি
Lordship.
Lordship was pleased to fix one matter at Yes, Lordship was pleased to fix one matter at 3 p.m. Lordship today. A land matter, Lordship.
All are ready?
Today I am supposed to address my argument. Mr. Basu has already, my lord, finished, my lord, his argument, Lordship.
Yes. You are ready? You have all completed.
কালকে কি আছে কালকে?
Reply.
What to say? Without
Yes, possibly that is with regard to item 53. 54 and 55, I believe, my lord, subject to correction, Mr. Basu has not yet started. All the matters are, my lord, fixed.
Now we are on 53, Lordship. Lakshya Trade Link.
No, we were minded to because other two matters, though it is being though it is being submitted that it is somewhat different, but it is pertaining to resumption. Pertaining to resumption.
In our matter, my lord, resumption order, my lord, has not yet been issued.
Maybe there that is the issue is that whatever
Retention order was
Bidhan
challenged by the petitioner. That was allowed by the
Resumption ki bidhan no?
And so a state or a lawyer is concerned, separate set of lawyers in state.
How can we deliver judgment in this without hearing the other two matters?
It has to be heard.
Uh-huh.
Those have to be heard, Lordship.
I know.
Other two also. Other two also.
Because we are having a separate set of lawyers.
You take over charge so that you
No,
can
no,
argue.
53, I am there. 54, learned GP himself will argue. He has told me that if you complete, you tell me, I'll start.
But we want to finish off the matter. We don't want to keep it in our hands.
Proceed.
one thing.
The moment.
May I one thing, my lord? So far 54, 55, my lord, there, my lord, gulf of difference for factual aspects are concerned.
No, Sister,
I
you do not, there is not that we will hear all the three. All the three.
Not gulf
আর
of
আজকে
difference.
সকালে একটা হলো না? 4th March 2 p.m. Hardly learned advocates appearing for the respective. এটাই
হয়ে গেছে তো অর্ডার দিয়ে দিয়েছে
ওই দুটো একসাথে থাকবে কোনটা না এটা না এটা শুনছি সেটা
I'm ready. I'm ready with.
আর অর্ডার দিচ্ছে আবার রেডি কি হবে
is the matter for
I'm ready to advance my.
on 4th March as fixed at 2 p.m. ওই দিনকে ওই দুটো দিয়ে দেবে ওই দিনকে
4th March, on that date, we shall not keep any other matter, that would be.
Lordship would subject to Lordship's kind consent, fix up a time.
We have said
2
at
p.m.
4th
March.
Mr. Mitro, we want to hear three matters side by side and finish it.
Three matters first, petitioners we have entirely, thereafter respondents will be taken.
Yes. That as we cannot all the take up all the remaining matters, we want to heard the arguments. In one matter, I think private respondents are there.
Yes.
So we are keeping it on 4th. Mr. Galib will conclude his arguments.
Number so far 6-3 is concerned.
Wait.
The scope
Other
of private
two matters
responding is
also-
very low.
Other 2 matters also we will take up consecutively.
Yes. Now, in all
Yeah.
3 matters, petitioner will complete
No,
first,
we-
thereafter respondents will be taken.
No, no, how can it be? No,
And
already,
one matter he has completed.
one matter
Yes.
already he has
Another two-
completed.
Another 2, Mr. Basu will complete.
No, 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 no. I have to give reply to that particular matter of Mr. Basu's.
Yes, you give your reply.
So Mr. Basu has, learned senior Mr. Basu has completed. Only today he is supposed to give one charge.
Understand, Mr. Galib, we are wanting to express
Fourth
who has completed, we will hear it. So far as the other matter also, Mr. Basu will show us the differences and what are his grounds. What is the problem? We want to take up all the matters and dispose it of. You complete your argument. Now in the other matter where Mr. Basu is,
We'll have to start.
Very next matter, he will start. And if you're advocate, you better take appropriate steps that your engaged counsels appear on that said day.
GP, learned GP will address in.
In this matter, learned GP is not there.
No, Mr. Basu,
Other
when we heard it, we were thinking of completing the arguments and fixing it up for keeping it judgment reserved so that we can deliver them.
Yes.
But now the point is, when there may be technical differences and everything on these matters, we want to hear your argument pertaining to the other remaining 2 also compositely so that we can take up the
Probably
cases.
my lord will be feeling difficulty subject to my lord pleasure.
Not
The
sure.
facts are not identical. Had it been the
Yes,
facts
that
are
was my-
identical, application of law will be same.
To whatever
Point
facts
of
and
law same.
Yes.
Point of law.
To some extent same.
so you will take down your factual differences. We will take note of. We will
I
hear.
have to argue the other matter independently.
Yes.
Because the facts are different.
Yes.
The point of law is there, na? That you have already argued. You show us that if anything is to be
So
added,
let
we
me
will give-
complete one of the other day residue part. Let me complete 2 judgments. Your lordship was asked me to cite. I will cite that.
Yes, please give us 2 judgments. We shall go through that.
I will not place it. Today, my lord will not take up this matter.
No, we were thinking of keeping it. We have fixed a date and time.
Let me complete, my lord. Let Mr. Galib complete.
এটাই ভালো হবে এনডিবি
My lord's pleasure, whatever way. বলো কি আমার করে? ওপরে নিয়েছে।
না ক্লাব টুগেদার হলে প্রবলেম হয় আমার তো my lord, subject to
Mr.
your
Basu,
lordship.
why don't you give us those judgments which you are relying?
Only
Place it.
handover.
No, place it.
Yes,
Place it
that
and
I'm
give it. We are giving you 10 minutes.
Yes, yes.
ওই অর্ডারটাই থাকবে।
But my lord, 64, 65, my lord, there are factual differences are there.
Okay, we will hear.
Whatever factual differences we will hear.
Point
Yes,
of law তো তোমার different argument হতে পারে other than my what
So far as the query of Justice Chakraborty, whether the circular which has been shown to my lord. Justice Chakraborty's query was whether 1994 circular which details that this type of lands are non-legal tenant, that has been taken care of by any other court. One reported judgment where, my lord, this circular has been quoted in extenso and considering. But we are not concerned with what happened, the outcome of that second appeal. So that is reported in 2005, AIR 2005, Calcutta, 190, paragraph 45. ICC.
Paragraph
ICC. 2005.
2006, 1 ICC, 592.
6-1 ICC.
2006, 1 ICC, 592.
কোনটা?
এর রেফারেন্স দিন
55.
এর রেফারেন্স দিন না
At page 198.
এরকম আপনি
This is land from Mr. Partha Sarvasya. Open করে বলি। Supreme Court reported. ইচ্ছে করে FLR দেখাবে, কারো কাছে নেই।
Exactly.
Yes.
This has been quoted in extenso.
Paragraph 55.
55. The circular.
Your circular. Your circular.
My lord's query was whether it has been taken cognizance by any court or not. But ultimately, the court in this second appeal dismissed the second appeal. But that is not the concern. This judgment, this circular was taken note of and accepted that this is valid in the eye of law.
Yes.
Yes.
Yes. Just a minute.
আদাম হচ্ছে 2018 এসএসসি অনলাইন ক্যাল
Online আমায় দেখাবি।
Yes, next
My
one.
lord, next, my lord, I am relying on 2019 2 Calcutta Law Journal, ভদ্রলোকের জার্নালে 2019 2 Calcutta Law Journal 582 বই আমার এসেছে
582.
582
Which paragraph?
বই কোথায় নেই আমার এটা পুরোটাই মানে in this case what happened is
সেটা এখানে লেখা আছে।
আদম এই তো এটা কিছু কম
2017 we had added over 3
একে দুটো আসেন তো দেখি
No, no, Mr. Basu has played reliance on 17.3 CHN. Yeah. 17.3 CHN.
Yes.
15.3 CHN.
Yes. 658.
15.3 CHN, 658. And OBG tie-up versus
tie-up, I have shown
2023 SCC online. These are the three earlier judgments.
I have cited. Now today I have cited, my lord.
No, you cited this judgment of Justice Horish Tandon.
Yes, OBG tie-up.
Oh,
OBG
that is
tie-up,
reported.
OBG tie-up. And now, my lord, I try to satisfy lordship's
No, my learned friend on last day cited two judgments. Jui finales, OBG tie-up.
15-3 CHN, 17-3 CHN, BRC.
BRC.
And my lord, today I have cited, my lord, 2006 1 ICC. Oh, sorry, KIR. I have just now handed over to lordship.
2005.
That is in respect of the circular.
You given us 17.3. 17.3.
That is on the last occasion.
কোথায় ডক্টর
17.3.
No, আছে
17.3 not with us.
2017 volume 3.
17.3 is with us.
Yes.
Not 7.3.
15, 2015.3. Have you given?
Yes, 15.3.
15.3 টা Mr. Basu, we have taken.
Given or not given, I have referred to because Jui finance are taken care of.
Oh, no, it has not been handed over.
No, it was not given.
Not necessary, I am multiplying only. Because BRC means 2015-3 CHN has been considered extensively in Jui finance.
That is 17.3.
17.3. Okay. And today, my lord, I have cited to your lordship 2005
5 Calcutta 190.
This is taken note. This is for the purpose of
circular
which has an authentic value or not. Now, my lord, another judgment I am citing 2019 2 Calcutta Law Journal 582.
Paragraph. সেটা দিল 19.
Paragraph.
স্যার একবার বলুন 19.2
19.2 Calcutta Law Journal 582.
No, yes, Calcutta Law.
হ্যাঁ কোথায় বলো মেলে না But kindly come to paragraph 12.
This is after Jui finance.
After Jui finance. And this will travel to Supreme Court with এটা না ওইটা Jui finance Supreme Court unsuccessfully.
ওটা দেয়া হচ্ছে
Which paragraph is in?
Paragraph 12, my lord Khalidi. The entire gamut of the legal proposition has been summarized here and answered by the court. Here, my lord will get Dakholkar and Bosot Proja. Because my lord's query was whether Bosot Proja is coming under the.
That is your argument, Mr. Basu. Paragraph 12.
Yes.
Where is the.
Coming to that, kindly be satisfied that Dakholkar and Bosot Proja was subject matter.
Yes, yes.
Now, my lord, the submission of Mr. Paragraph 13 is his submission. Kindly come to 19 paragraph. Yes. But now, kindly come to 20.
Yes.
Actually, yes. My lord, I'm sorry, my lord, kindly take paragraph 19 first. Because 67 Supreme Court, which is the parent judgment in this field, has been quoted in extenso. That paragraph 9 was quoted. Then kindly come to 20. The nature of user of the land on the date of vesting, my lord, kindly mark this. The nature of user of the land on the date of vesting and the nature of the original used by Ganges jute mill in that case, that was enjoyed by the BJM after purchase from Ganges Manufacturing Company Limited was for the purpose of running a jute mill, and as such, the nature of user was non-agricultural. Admittedly, the petitioner BJM had purchased 35 acres of land from Ganges Manufacturing Company Limited with Mokgori Morosi right. The terms Mokgori Morosi has not been defined, but as per the commentaries on Bengal Tenancy Act, Mokgori Morosi meant a tenant with payment of fixed rent. According to the definition of the tenure holder, acquired a right from the proprietor to hold the land for the purpose of collecting rents for the bringing the land under the cultivation by establishing tenant on it. The definition of tenure holder thus keeps BJM outside the purview. Now coming to the definition of intermediary under the said act, we find that although a tenure holder was included within the definition, but in the instance case, Mokgori Morosi right related to land comprised of mills, factories, staff quarters, etc., which were non-agricultural land. And these lands, having been used for non-agricultural purpose, would not vest in the state under the said Act of 1953, as non-agricultural tenants were not intermediaries. The contention of the respondents that the petitioner was an intermediary as they enjoyed Mokgori Morosi right in respect of the land in question purchased from Ganges Manufacturing Company cannot be accepted. Then 25, all judgments were quoted. Admittedly, the land purchased by BJM, here kindly put me, from Ganges, my vendor company limited, was for non-agricultural purpose. The contention of the respondents that the said lands were not agricultural tenants as the Non-Agricultural Tenant Act 1949 did not apply to the areas in question does not impress us. As per definition of non-agricultural land and intermediary under the said Act of 53, and also upon consideration of the nature of user of the land by the Ganges Manufacturing Company Limited and subsequently by BJM, it would be evident that the same was for non-agricultural purpose. Kindly compare it with the present case. There is another aspect in the matter. Section 44(4) of the Act of 53 categorically provides that every entry in the finally published record of right shall be presumed to be correct. Here, my lord, kindly see our record of right. Admittedly, BJM was recorded in the finally published record of right as Dakholkar. Here, Bosot Proja. And as such, the land of BJM were non-agricultural land and the BJM was a non-agricultural tenant. What I think, my lord, nothing more is required for my lord to decide this case according to my humble service. 26. Rest part, my lord, the read petition was.
Thank you.
So next, shall I start, my lord?
Record of right, my lord, I have shown to your lordship record of right.
Yes.
Dakholkar Bosot Proja, and my vendor's name was also there. Should I repeat?
No.
Start.
এটা তো বলে দিয়েছি তো।
Next day I shall start.
Yes.
My learned senior friend has completed.
Yes. You start and please make on our part make an endeavor that who are the other two learned advocates for the state, so that after you finish and Mr. Basu shows us the factual differences in two cases, we can finish it off with you.
I shall intimate him accordingly.
Please, if you can.
I have a prayer. Whether my lord will accept it or not, I request your lordship to segregate these two matters and to hear independently. And It will fix up. I will not be able to assist your lordship properly. That's why I am apprehensive. This is my fault, not the fault of the court. But it will better if lordship decide an issue in the judgment. That will follow all judgment, all matters. Up to my lord. That is up to my lord. If my lord is deciding a rescue in a judgment, then follow automatically.
Very hurting part আছে 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 it's a hurting part
Order 4127 application. I forgot that. Order 4127 application. Yes. Well, kindly once take up that. Which one? Can one.
देखिए तो order 4127 application টা দাও
Yes, what you want to point?
Well, kindly come to page 10. Kindly come to the description column. This is of 1961-62. Chatterjee, kindly got it? Oh, thanks. মনে করাবি তো ভুলে যাচ্ছিলাম এক্ষুনি Yes. Well, kindly got it? Kindly come to the description of the premises. Page 10 or 16, whatever. In all documents I have annexed the demand register. 16 time mark 16 time that.
Yes.
First column kindly see. 1P2 state house for school building such and such, PL such and such. Why I am showing that? This is constructed. And the year quarter is 50 to 53. If you also kindly turn to page 16, you also will find that period 50 to 53. So prior to coming into force of Estate Acquisition Act.
Which page you
16.
Page
16, 16.
10.
Same, only thing is the period is different. Can you see at the top?
50 to 53.
50 to 53. So it is prior to coming in.
Prior to waste.
47, 48
long, at least from 47, not necessary, 53, 50 is enough for the purpose of this matter. So it is not a vacant land. 47, 48 to fourth quarter, 50 to 53.
covered by
May I assist Chatterjee?
B এটাই বলতে চাইছি
Column number 6, 7, 8. My vendor's name will be there, is there. Howrah Trading, my vendor, and the construction is on the land. So it is not a vacant land to be vested under the Estate Acquisition Act. And it is lordship knowledge on the basis of this ROR is, I have shown to your lordship, ROR also depict that this is a non-agricultural tenancy.
All right, thank you.
RBC bolle conduct.
Anything else you want to show us, Mr. Bas? No.
ভুলে যাচ্ছিলাম সেই
শুধু 61 এ অর্ডারটা হবে আর ওই দিনকে ওই দুটো আর ওই আজকের যেটা ছিল এটা একটু মনে করে Yes,
all three matters.
All the four matters. No, you will get some time. We will hear Mr. Galib on that day. Then you come and tell us about the factual.
1 month gap.
Okay.
1 month gap.
Gap may be 1 month, but experience 40 years plus.
In yellow, আমার পেছনে লোকে লাগে। It was entirely leg pulling was entirely my prerogative. Now, my lord, I'm old man.
You're facing the music.
This thing remains now. That has no age. Should we use
It is easy to say I am old man. Have you acknowledged it? Yes.
I have to acknowledge. Today I could not come to court due to my illness. In code number, Justice Bhattacharya
Old age ailments.
2 days.
Old age ailment.
So mentioned that Mr. Basu is ill. He has not come to court. Just that he must be somewhere. But no, my lord, he is ill. What are you telling? Last 30 years I never seen him ill.
No, stay well.
Then I say, my lord, its indication is I am getting old.
We are also happy to learn that.
Chart nahi.
Yes, Mr. Laidi. কোথায় গেল?
My lord takes the impugned order. My lord takes the impugned order. Which is at the original paper book.
Yes.
Oral submission.
Page 54. And then my lord kindly takes
Page 54.
54 of the paper book filed by the appellant. No.
Yes, 54. Yes.
My lord kindly takes page 55, the third paragraph. This is the version of the advocate for the state.
I read it out.
Please, sir.
Mr. Laidi, please place that.
May I? Mr. Amitesh Banerjee, learned senior advocate, represents the respondent as well as the respondent number 4 in his usual fairness. Submitted that going through the records of the case, he found that the impugned resumption order was not preceded by issuance of 6 months prior notice as mandatorily stipulated by the proviso to clause 4 of the said lease deed dated May 3, 1983. It is a concession order. This order is on basis of a concession made by the state advocate. This concession has not been challenged in the memo of appeal.
It's a weak ground. That is a weak ground.
No, I'll come.
Mr. Das, he has not disturbed you when you made your submission. Yes.
But my lord, now primarily, my lord, this is a lease.
Yes.
This is this is a lease between the petitioner and the state. So a lease can only be terminated
Yes.
But a lease can only be terminated if there is a violation of the condition of the lease. And it must be preceded with a notice. According to Transfer of Property Act 106, it's a 15 days notice. But this agreement provides that it is
transfer by 15 days notice for
106. 106. But this agreement, my lord, provides, my lord, may I place the clause 4 once again?
Yes.
But clause 4 is a page 35 of my paper book, my lord. My lord, may I place, my lord?
Page 35.
Page 35 of the paper book by Mr. Subhashish Shah. Supplementary paper. Yes. If they would have given every documents in one paper, that jumping from one to another.
Which page you are showing?
Page 35.
Page 30.
Yes. Well, may I place it once again? provided always that. My lord has got it.
Para 35.
Page 35, para 4.
Yes.
Provided always that if there is a breach of any terms and conditions, my lord, I'll pause here for a moment and then go on. And covenants herein on the part of the lessee, content, the lessor shall have a right to re-enter possession of the demised land or part thereof in the name of whole, and thereupon this demise shall forthwith that determined. So it's a determination clause under the lease. Now, provided nevertheless the lessor shall not exercise right without serving the lessee a notice in writing, giving 6 months time to remedy the breach. So there must be a breach, there must be a notice to remedy the breach, and that remedy must be a notice of 6 months. Now, what is the notice? What is the breach? The breach is 2/6, my lord has been read, 3 years I have not constructed. So, my lord, prior to this issuance of notice, whatever I have done prior, there was no notice. Prior to 2017, if I have violated, there is no notice. The first notice comes as a show cause in 2017. Show cause, I reply. The show cause, my lord, I again place, my lord, the show cause. The show cause is at page 59. In the show cause, the only violation is 2/6A, not 2/8.
Page 59.
59.
Yes.
It refers, my lord, kindly takes third paragraph, fourth paragraph. And whereas the show cause notice was earlier sent, which was returned as not known, same was resent on 2001, middle of the page, my lord. But then, whereas a survey report filed by the surveyor 11/1/2017, the plot is line second, original lessee Kalicharan, you have failed to construct your house and thereby violated the safe clause. You are requested to explain within 30 days as to why the plat leased out shall not be resumed by the government. This is a show cause. 30 days show cause. This notice is not also 6 months.
But why it is under 2/6A?
Because I have no construction. No construction. Immediately what they do giving the show cause, they put a board. They put a board. What I reply to the show cause? What I reply to the show cause saying that next page.
Yes.
Now we say about the gift deed by the sisters in the second paragraph. Now we say third paragraph. Then we two brothers plan to construct the building on the plot of land. Accordingly, we got sanctioned on 9/1/2003, and all of a sudden my transfer to Mumbai. I am posted out of Kolkata. My brother, as his service concern, always posted far from Kolkata. We could not materialize our plan to construct. I have recently come back to Kolkata and posted at Shakuntala Park branch. We are planning to construct building shortly. But we found that you have implanted a board stating government has taken the plot of land. So even before the answer to show cause, they put a board. You are requested to remove the implanted board in our plot of land. So after the show cause, they put a board. I say remove the board and at least allow me to construct. We reply to the show cause. What they reply?
No, you don't say that.
Yes.
Remove the board and allow me to construct. That is.
I want to construct. Come back to Kolkata. We are planning to construct the building shortly.
Planning.
Yes. We are planning to build, but we found that you have implanted a board.
1998, you are going on plan. Went on plan.
Now, my lord will kindly see then.
In view of the taking note of this first stand of the state, the single judge or the order, we will finally non-mitigate. All these orders are not.
They do not write.
These orders are not preclude the state. The appellant from taking up these steps in accordance with law and as per the terms and conditions.
Assistant England করে
No, it is good. Yes, notice this.
But they do not write to us by refusing us, saying that no, you cannot construct. He said, I will not remove the board. The next page. And thereafter, my lord kindly then takes the notice. It says 15 days. Notice at page.
Which 15 days?
69. Resumption notice. Will not re-enter without giving 6 months notice. This is 15 days akin to 106. This 15 days is akin to 106.
The present appeal has been preferred. Challenging an order delayed.
And 8th January 2021.
28th January 20. Cost to you. You may argue that by issuance of that memo, earlier action which was there, you did not take any steps.
All are
Those kind of-
technical issues.
Understand, madam.
27
It
years,
has to be thrashed out because you also want to build. Na?
I want to build.
So let them take appropriate. If they do not take, you have your remedies open. Salt Lake Properties, sir. 22 years it has been kept
27
vacant.
years it is going.
27. That's too much.
unutilized you are left. 83, 42 years. Oh, so
সেটা এবার বলো কি আপনি?
বলে দেবো বলার
Yes.
My another writ petition is pending. After the writ petition been disposed of, I have
Filed another.
I have filed.
All right. Yes.
Well,
Next.
oblige, madam. Oblige, madam.
আরে বাবা তোকে সারাউন্ডিং এরিয়া
I am the I am preparing for the respondent.
আচ্ছা
6 to 13 and 15.
হ্যাঁ হ্যাঁ 6 to
6 to 13.
respondent.
Respondent number 6 to 13 and Millet 15.
Item number 26.
Order dated second.
মঙ্গল কুমার পুরকার।
Order under.
May I file the affidavit in opposition, Millet?
Reply you file, Mr. Bose?
Opposition দিয়েছে না রিপ্লাই দেওয়া আছে রিপ্লাইটা ফাইল আছে তো হ্যাঁ আমরা রিপ্লাই দিয়েছি কথা বলছো তোমরা রিপ্লাই দিয়েছো আমাদেরকে দিয়েছো রিপ্লাই তো দিয়েছো তুমি
Did you serve copies upon this?
Yes, Millet.
রিপ্লাই তো দিয়েছো
Oh, reply দিয়েছে? ও আচ্ছা ঠিক আছে।
Millet, 2nd May 2023 is the order at page 164.
One 164.
160. Right.
হ্যাঁ
Yes. Now, Miller, the application for mutation was pending before the concerned authority. Against inaction, Miller, the petitioner moved before the Honorable Tribunal. The Honorable Tribunal, Miller, 165, Miller.
Oh, have you seen gone?
Yes,
through
yes,
that?
it lends assistance.
No, no.
Yes, yes.
Indian.
Miller, here the, yes. Miller, since
please,
Miller, the principle, Miller, as I understood, Miller, since the mutation does not decide the title of the property and it was done on the basis of the will, and Miller, the mutation is made on the basis of the possession. So, Miller, the question of non-grant, kindly see 789.
That is the.
Yeah, yes, but still, Miller.
The facts.
Yes.
You have gone through that. Judge?
Yes, Millet, I have gone through.
Yes,
It
you
helps
please.
me, my 45 is my case, Millet.
Yes, actually, that I
Yes,
was.
Millet.
I after reading this came up.
No, Miller.
Anyway,
Yes. Miller, here what is the case, Miller? The case is, Miller, a will was probated and Miller, on the basis of the will, Miller, and the basis of the possession, I made an application before the BLRO. Now, what way? Now, Miller, the BLRO did not take any action. Now, against inaction, when I approached the Honorable Tribunal, the Honorable Tribunal says, kindly sees, learned advocate Srikant Pal appears on behalf of the applicants and submits applicant's great grandfather, late Jagabandhu
where
Purohit,
you are reading, Mr.
165.
165. Yes.
Learned advocate Mr. Srikant Pal appears on behalf of the applicants and submits that applicants. It starts from 164.
164. Yes, it starts. But Srikant Pal, where did you?
Then 165.
165. না না সে তো প্রথম পাতা আছে
Oh,
সেকেন্ড পেজ 165 where is Srikant Pal you are getting
Miller, this is in my brief, Miller. Srikant.
it is 165 Srikant Pal
Yes.
164 in our copy
Yes, yes. I'm reading that. Miller. I'm sorry, Miller. Learned advocate Srikant Pal appears on behalf of the applicants and submits that the applicant's great grandfather, late Jagabandhu Purkaid, executed a registered will in the year 1942 and present applicant is son of Shoilendranath Purkaid. He is a beneficiary of that will, but in ROR, name of the all beneficiaries has not been recorded correctly and the name of Shoilendranath was recorded as Dakholkar. That should be corrected. One Mongol Kumar Purkait, one of the legal heirs of Shoilendranath Purkait, for self and on behalf of the other legal heirs, made representation before the BLRO Baraipur on such and such date. Till today, the same has not been disposed of. So appropriate direction may kindly be given for disposal of that very representation. Learned government representative is present. Learned advocate Mrs. Mousumi Mollik appears on behalf of the respondent number 6 to 13.
Private
by
respondents. These were
Yes,
private
he,
respondents.
my learned friend.
Oh, you were.
Yes, yes.
So, Millard, by the first court of civil judge, senior division Baripur submitted that the honorable court was pleased to direct the title suit to maintain status quo as regard nature, character, and possession of the land is questioned. So, if an order is passed directing the BLRO to interfere with the status of the land, that should be violative of injunction. Besides, that learned government representative referring the representation which was preferred by the BLRO Baripur dated such and such by the applicant, this very representative not all maintainable, as because all the legal heirs did not put their signature on the applicant or participated in the representation. Learned government representative further submit that it is true, it was written in the representation that it was submitted on behalf of the late Shailendranath Purokait and on behalf of his son and self, but that very representation without any power of attorney of those persons cannot be entertained. Moreover, learned government representative further submits that in the instant case, applicant prays for correction of the RS which is at present barred by law. In such circumstances, on the part of the BLRO, there is no inaction. As such, this A and B same is liable to be dismissed. At the outset of our discussion, it is pertinent to point out that as per section 44(2)A of the WE Act, at present, RS cannot be corrected or interfered with. Moreover, in this case, we find an order of injunction, civil case number TS such and such. However, on this point, an advocate of the applicant was given liberty to file documents to show that the very suit has been disposed of or that very injunction order is not alive at present, but learned advocate of the applicant expresses his liability to file any document to that effect. Besides that, the representation which was preferred before the BLRO is in fact defective, not in proper form. In this instant case, the name of the interested parties to whom notice should be sent by the BLRO. In the event of initiation of proceeding for a hearing, their name has not been mentioned by the applicant in the representation which was filed before the BLRO. That apart on scrutiny, the record we do not find that the other legal heirs of the late Shailendranath Purkayat ever given authority to Mongol Kumar Purkayat to prefer this representation. Besides that, it appears to us that the letter of administration was granted by the concerned court in 1946, and on the strength of that very letter of administration, after 76 years, applicant pays for correction of the ROR. It is in fact an effort to move the hands of the clock to its back. In such circumstances, we are of the opinion that the applicant fails to make out a prima facie case of the inaction on the part of the BLRO. So we are not at all inclined to issue any direction to the BLRO, and we are of the opinion that OAB and the same merits dismissal. Accordingly, let a plain, the same is dismissed, let a plain copy. So this is, so Millard, the two things Millard disturbed Millard, the honorable tribunal. One is Millard 1946 Millard will, and that is why this is, and 44(2)A impediment creates impediments, that it is a time barred application, it is barred under law, and Millard the civil suit injunction, whether injunction is alive or not. Now Millard, I will show your lordships, Millard, I will answer the information script work on. Page 44.
You show us your representation.
Millard, only Millard, I will show your lordship, Millard, I will. Kindly seize Millard, page 41 and 44. (41) and 44.
Yes.
Now, Millard, Pita Birendranath Purkait and Shailendra Purkait. My lord has got it, Mantobbo column.
Yes.
Yes. So this is Millard Mantobbo column. It says Millard, and then 44.
44.
Yes.
It was recorded in name of Sushila Baladasi.
45, Sushila Devi.
Daughter of Dhirendranath Purkait.
Kindly comes to Millard 45, Mantobbo column. Pita Dhirendranath Purkait, Dong Shailendranath Purkait, Dakolkar. This is LR record of rights under Land Reforms Act. And 41.
41 is RS.
41 is RS under Estate Acquisition Act.
Dhirendranath Purkait, Dakholikar, Shailendra.
Dakholikar, Shatto Dakholikar. Now, my lord, what is now, my lord?
The private respondent.
Private, no, that is, my lord, our predecessor in interest, the holy card.
Oh,
My grandfather, now, my lord, the grandfather, now, my lord, section 3A, my lord, of the Land Reforms Act.
Non-agriculture tenant.
So it was given effect to 9980. So, my lord, the law is, my lord, on the date of vesting.
Estate Acquisition Act.
First Land Reforms to the section
Land
3A.
Reforms Act না?
Yes, my lord, this is the
এটা you give it back. আমাদের আছে।
Land Reforms, this is asset acquisition.
এদিকটা বের করো এটা। ওটা ওকে দিয়ে দাও। Yes, what you say?
Land Reforms Act, my lord, 3A.
Yes, 3A, what you
Rights of non-agricultural tenants and under tenants in the non-agricultural tenant. Rights and interest of all non-agricultural tenant and under tenant under the West Bengal Non-Agricultural Tenancy Act shall vest in the state free from all encumbrance and the provisions of section 5 and 5A and the provision of such and such 5 and 5A of the West Bengal Estate Acquisition Act shall apply with such modification as may be necessary mutatis mutandis to all such non-agricultural tenant, under tenants, and as if such non-agricultural tenants and under tenants were intermediate.
Agricultural tenants were West
Non-agriculture tenant. Sarabiyat করলো এখানে। Those who are
So non-agricultural vested on
9980 given effect to. Now, my lord, admittedly, my lord, the Porcha, RS Porcha Divisional Settlement, my lord, is a sequel to the promulgation of Estate Acquisition Act. Now, my lord, on the date of vesting, my lord, if, my lord, the person concerned, my lord, described as a Dakhulkar was in possession, he becomes a Rayat. No dispute to that. So, my lord, in terms thereof, my lord, after promulgation of 1954, this act, section 3A, now, my lord, is a non-agricultural tenant. And, my lord, what is the law on the subject?
What is the classification of the land?
Khali.
Khali to non-agriculture.
But I am a tenant, my lord, because I tell your lordship.
The date it has. Khali means agriculture land.
Yes. Now, I am a tenant non-agricultural, I said. Kindly see. Well, there is a room, my lord, on the land.
Determine your status, Mr. Vasu. Can we determine your status
No,
today
beloved,
that you are in possession as a non-agricultural tenant? Classification of the land is Shali.
Agriculture land, and you come to page 44, there is a Borga.
There is a
Borgada. Borgada non-agriculture tenant land.
My lord, this is
Borgada who cultivate.
now, my lord, in my case, my lord, there is a room, my lord. There is a construction on the land. That is partition should, my lord, plain, my lord, kindly see.
Our the record of rice speaks.
No, Ella record, my lord, only two things. That on the day
Mr. Basu, we cannot go into that.
It takes time.
As a matter of fact, Millard, there is a partition
Millard,
paint.
no.
Yes, Millard,
Millard,
yes.
in the Millard, in the will, this has been described 1945, much before the Millard. This was probably 1946. Millard, it was described as Vastu.
No, we are not. You have rightly.
That means Dhirendranath Purokat has been treated as a Raya. Susila Bala Raya. Column number 5.
Now, if I become a riot, then the question is.
That means you become the owner within the 4.1 of Estate Acquisition Act.
So, Millard, the partition suit that is pending in the court below, Millard, they said that there is an injunction or learned advocate could not produce a paper. Page 158, Millard, of your lordship's brief. Page 158, there was an information slip.
In partition to your party.
Right.
Yes.
So you prove your title
Yes,
there.
No, they are not questioning my title. Millard, the will.
Partition suit means title will determine thereafter heir will be declared.
Millard, in this suit, Millard, Millard, kindly sees the what.
We are saying that there may be a necessity of further change of record of rights
My lord,
after degree of partitions.
my lord, in terms of section 14 of the Land Reforms Act, that if I get the partition decree or registered, then my lord, yes,
Section,
eh,
50 and
yes.
any change.
Now, my lord, any change. Now, my lord,
Let your status be determined.
my lord, only one indulgence, my lord. I am seeking. First of all, my lord, there are two things, my lord, which disturbed, my lord, the honorable tribunal not to pass any order. First, my lord, it is a time bar. I said, my lord, section 51 of the Land Reforms Act.
Forget time, but because of the fact you made a prayer for correction of RS
Correct.
record of right.
Right. My lord, kindly cease, my lord.
RS record right, there is a specific time. On
50
application
years.
44 2A.
44 2A. Yes, yes, yes. That is 50 years.
Of the
50 years.
50 years government. You
Government.
can
No, no. I said, my lord, that 51 of your lordship's, my lord, act that empowers, my lord, the government. Kindly cease, my lord, 51 of the section 51 of the Land Reforms.
It is always, there may be
51 section.
land reform, LR Act,
Sorry, my lord, 50.
LR
These acts.
land reforms came after the estate act.
Yes, yes, my lord.
It would be
Five,
after
five,
section
zero.
50,
50, 50, yeah, 50. And Rule 21.
Yes, Rule 21, yes.
Yes.
Whenever they change.
Whenever the answer is, my lord, the 50. Kindly cease. So, my lord, the point of limitation which the Honorable Tribunal has said, the prescribed authority shall maintain up to date in the prescribed manner and the village record of rights by incorporating in the changes on account of mutation of names as a result of transfer or inheritance, partition, exchange, or consolidation of lands comprised in such and such land, establishment, new settlement of land, variation of revenue, alteration in the mode of cultivation, for example, by Borgadar, such other causes as necessitates a change in the record of rights for every mauja in any district for which computerization of land record has been completed. The original set of finally published record of rights prepared under section 51A for such mauja of such district shall be preserved, and a set of computerized printout of the finally published record of such mauja duly authenticated by the prescribed authority shall be taken up for updating and for the issue of certified copies. But this is not number, and then we'll have Rule 21.
Rule 21 you have to give our the book. Rule 21.
Hey, this is the whenever the changes is required to be made in record of rights on account of any of the causes mentioned in A to F of section 50, the matter shall be brought to the notice either by the of the revenue officer, especially empowered by the state government for maintaining up to date the village record of rights and all papers. So whenever the change, so Millard, it cuts Millard the point of limitation. It says, Millard, whenever the Millard, yes, I have changed.
RSROR was prepared under West Bengal State Acquisition Act that can be corrected under section 44(2)(a).
That is, Millard?
44(2)(a), there is a time limit. For applicant 9 months, state is now 60 years. State can do it within 60. Now it is.
Millard, I applied for the correction of the LR record of rights. 30th December.
Where is your application? And implementation and we are
application.
So long your claim was that you have applied for RS.
No.
And hence they are saying yes.
Right.
You show us your implementation.
Millard, 122. দাঁড়া 153 টা বার করতে
122
153 153 দেখতো একটা নিচে না পাতাটা
come to what?
No, Millard, no, just a minute. 153 last annexure P4 sorry 53 Millard. So only 53 Millard. আমাদের বিনীত নিবেদন এই যে আমাদের স্বর্গীয় প্রপিতামহ ভগবন্ধু পুরকাইত সাচান সাজ তিনি তার জীবদ্দশায় নিজ নামীয় দক্ষিণ চব্বিশ পরগনার স্থায়ী বাসিন্দা ছিলেন। তিনি তার জীবদ্দশায় নিজ নামীয় সমস্ত স্থাবর অস্থাবর সম্পত্তি গত 27/9/1942 সন তারিখে রেজিস্ট্রিকৃত উইলনামা চারি পৌত্র ফণিভূষণ অবনীকান্ত কিশোরীমোহন শৈলেন্দ্রনাথ গণের নামে করিয়া গিয়াছিলেন। যাহা উপযুক্ত আদালত হইতে প্রবেট নেওয়া হয়েছিল, যাহার কেস নাম্বার সাচান সাজ, ডিস্ট্রিক্ট ডেলিগেট আদালত সাচান সাজ, তাহাতে উল্লেখ থাকে যে ফণীভূষণ পুরকাইত, অবনীকান্ত পুরকাইত, কিশোরী মোহন পুরকাইত তাহারা দুইয়ের তিন রকম অংশ করিয়া পাইবে এবং শৈলেন্দ্রনাথ পুরকাইত কেবলমাত্র একের তিন অংশ পাইবে। এছাড়া উল্লেখ থাকে যদি কোনো পৌত্র পুরুষ ওয়ারিশ না রাখিয়া পরলোক গমন করেন, তাহলে তাহার তক্ত সম্পত্তি জীবিত পৌত্র পাইবে, মৃত পৌত্রের কন্যা বা স্ত্রী পাইবে না, ইহারা বর্তমানে মৃত। এমত অবস্থা আমরা দেখিতে পাই যে উইলের শর্ত অনুযায়ী স্বর্গীয় জগবন্ধু পুরকাইতের স্থাবর অস্থাবর সম্পত্তি আমাদের পিতা শৈলেন্দ্রনাথ পুরকাইতের নামে রেকর্ডভুক্ত হইয়াছে, কিন্তু তাহার মধ্যে মৌজ ইন্দ্রপালা সাচান সাচ নামে দাগ they have described the act. মোট জমির পরিমাণ 247 শতক জমির উইলের শর্ত অনুযায়ী রেকর্ডভুক্ত হয় নাই, কিন্তু উক্ত জমির দখলিকার আছেন শৈলেন্দ্রনাথ পুরকার অধীনে দখলিকার আছেন বর্তমানে। অতএব আপনার নিকট আমার সবিনয় নিবেদন প্রার্থনা, আপনি সরেজমিনে তদন্তপূর্বক উপযুক্ত প্রমাণ পত্র দেখিয়া স্বর্গীয় উক্ত জমি রেকর্ডভুক্ত করিবার সুব্যবস্থা করিলে আমরা আপনার নিকট চিরকৃতজ্ঞ থাকিব। বর্তমান রেকর্ডভুক্ত implies, my lord, that there is no scope for going back to the RSA correction, LR correction. So 50 empowers, 21 says in manner in which, so today, my lord, this cannot be, and the judgment, my lord, Justice Chakraborty, my lord, on the day, my lord,
That was a mutation.
this is also,
They are
this is
asking
also
for
mutation.
mutation.
Yes.
It is
They
mutation.
are asking for mutation.
Yes. Judgment handed করেছে।
Are you in possession? Any part
My-
of the property?
Yes, my lord, my instruction is. আমার জাজমেন্ট না, জাজমেন্ট আমাকে দিয়েছি, জাজমেন্টটা জজ সাহেবকে দুটো তুলে দিয়েছি।
Come tomorrow, Mr.
দিয়েছি।
Come tomorrow, yes, right?
Very well, Millet. If your lordship wants to hear tomorrow, Millet, but I am ready today. But it's 4:30.
Yes, yes.
But only thing is, Millet, their case, Mr.
We
S.
are keeping it tomorrow at 11 o'clock.
Very well, Millet. Yes.
কালকে কি কোনো
আগের দিকে দিয়ে দেবেন।
আগের দিকে রেখে দিতে পারবে না? হ্যাঁ? Order So heard Mr. Basul and senior advocate appearing for the petitioner.
দিয়ে দেবেন। এই
Mr. Basul and senior advocate who is responsible for the Mr. Basul and senior advocate appearing for the petitioners has concluded his argument. Due to paucity of time, Mr. advocate appearing for the respondent numbers.
Srinjoy Sengupta.
Mr. Monik,
Mr. Srinjoy Sengupta.
your surname, please.
Srinjoy Sengupta, Millet.
Sorry, I forget
No.
this. Mr. Sengupta could not complete his arguments. In view thereof, list the matter as for orders. In the এই পরশু দিনকে কি কোনো একটাই ফিক্স আছে? Tomorrow as fixed at 11 o'clock.
I'm grateful.
Lordship, I am led by Mr. Somnath Ganguly for the state.
Ask him to be present.
Lordship.
ওপরে সোমনাথের নামটা
এক সেকেন্ড।
Let the affidavits exchange করে দিয়ে দিও। Let the affidavits exchanged by the parties be kept on.
Opposition কত থেকে কত?
6 থেকে 13 আর 15।